Hear. Court of Appeals of the City of Michigan is now in session. The Honorable Christopher E. Yates, the Honorable Kathleen A. Phoenix, and presiding Honorable Daniel S. Kowalski. All persons having business to draw near, the petition and shall be heard. God save the United States, the State of Michigan, and the court be the
All right. Well, good morning, everyone. Welcome to the Michigan Court of Appeals. This is the first day of case call for panel 5 of the court's March 2026 session. My name is Dan Karakin. I'm very pleased to be joined here today by Judge Christopher Yates and Judge Kathleen Feeney. A couple of opening remarks before we get started. We understand these cases are very important to you, to the litigants, to counsel. I want to assure you that they are important to us as well. We've been diligently working on these matters for a while now. We've had the benefits of your briefing as well as the work of our research division here at the court and our own chamber staff, which is to say we're familiar with the relevant facts, the pertinent law. So we ask that you focus your oral argument on your most important points, why you should prevail, and what is critical for us to understand. Okay. Finally, we are hearing matters, as we do always, involving sexual assault victims, personal protection orders, and children. So these proceedings are recorded. And so therefore, we're going to ask that you please use initials rather than the actual name of any victim or child or other vulnerable adult in these cases. In fact, it's usually, people are usually able to not mention even initials, and if you're able to do that, that's probably easier. But if you want to identify someone, please use initials rather than their full name, okay? With that, we look forward to hearing your arguments, and we will begin by calling item number 1, which is case number 366-332, People versus Gerald Lee Arbuckle.
Good morning, judges. This is Stephanie in the clerk's office. The prisoner is getting logged on right now, is what I'm told. Mike called the prison, so it may take a few minutes.
Okay, should we come back to it?
Yeah.
Why don't we come back to it, and we're going to go to the next item, and then we'll come back to item number 1. Okay. Sorry.
No, we did that all the time. We would tell them when we were going to start, and then they would say they would get them there, and then they would get them there that time-ish, sort of. So. All
right. So putting number 1 aside for the moment, we're going to go to item number 2. Docket number 367-786, People versus Johnny Ray Brown Jr.
Good morning, Your Honors. Angeles Meneses from the State Appellate Defender Office on behalf of Johnny Ray Brown Jr. Your Honors, we've raised 3 issues, and so I'll only hit just a few brief points as to each, understanding that Your Honors have read the briefs. Specifically as to the first issue, which deals with the prior bad acts testimony presented by the 3 prosecution witnesses against Mr. Brown. Again, this was every single prosecution witness that testified.
Can I ask you this question? No, you described it as prior bad acts testimony. The jury, as far as I could tell, didn't know what these other cases were about. They knew there were other cases, but they never understood the substance of any charges or convictions, did they?
No, Your Honor, there were no substantive convictions or acts testified to by the officers. However, their testimony that they encountered Mr. Brown more than once in the scope of their work.
Right. But just to make sure that analytically we get this right, it doesn't strike me as 404B evidence. It strikes me as potentially impermissible evidence, but for a different reason than 404B, right?
Understood, Your Honor, and I am open to that position. I do believe that it is still prior bad acts testimony because these are police officers testifying about Mr. Brown in their like interacting with Mr. Brown in their job capacity, and the testimony about it. Oh, sorry, go ahead.
Right, they certainly knew who he was. I mean, it's sort of like that Simpsons episode where they come in because there's a meltdown and they all say, "Hi, Homer," because they're so used to seeing him all the time. I mean, when one of the officers runs out to the guy at the Sally Port, he said, "Did you see Johnny run by?" I mean, they know who he is. It's a small town, right?
Yes. And but furthermore, there wasn't just testimony about his, which the prosecution points out, that they claim that the testimony about his tether experience was only pertaining to his tether experience for this particular instance, and that they claim that Mr. Brown opened the door up to that testimony. However, when the prosecution elicited further questioning, it was about prior experiences on tether, alleging that Mr. Brown had previous cases for which he had served time on tether.
But I think that part of that was just impeaching him because he said he was only on tether once when he testified on direct. And so on cross, the prosecutor was just trying to show not that he'd been on tether, not that he had a prior record, but that he was lying.
Your Honor, I don't believe that, from my recollection, that Mr. Brown ever testified that he was not on tether at another point. I don't believe that he alleged that the prosecutor did characterize part of Mr. Brown's testimony as lies, which actually does speak to the third issue in this case. But
Right, and that's a separate problem. But assuming that he said on direct he'd been on tether once, you have to concede that you could then cross-examine him if you'd been on tether multiple times, right?
yes, I would have to concede that. However, what the prosecution was characterizing as a lie specifically at that point about Mr. Brown's testimony was the fact that he claimed that he had not run from the police officers, that he thought he had had a negative drug test, despite being told that it was a positive drug test. Right. So that part specifically at that point was what the prosecutor was characterizing as lies. But I would concede that if Mr. Brown did testify to that, that would be a fair correction.
But it seemed like Mr. Brown was almost his own worst enemy, because he mentioned more than I think his counsel really wanted him to mention with respect to his prior involvement with the law. Wouldn't you agree?
In some respects, yes, Your Honor. And we have to concede that Mr. Brown did raise the fact that he knew he had been in and out of the tether office. He had joked with the tether officers before about whether or not he dropped dirty, quote unquote, or not. And that's why he thought that when they told him that he tested positive, that this was a joke. So he did admit to that. However, the prosecution's cross-examination went beyond that scope. It talked about even more prior experiences not related to this particular case. Mr. Brown did talk about being on tether for 2 years in association with this case, which lent itself to his familiarity with the tether officers here. But then the prosecutor went into further detail and said, okay, but you were on tether in this case, and then this case, and then this case, and introduced prior acts, which is where I think it gets to 404B.
His testimony was definitely a wild ride.
Yes, Your Honor. And that speaks directly to issue number 3, which is where the prosecutor did characterize Mr. Brown's testimony as lies impermissibly. Both.
Well, can we stop and focus this argument? Because this is one of those where they've conceded that was error. And I think there's no question it was error. It wasn't a question on cross-examination. It was a statement. So I think you can assume we're going to agree with you on that. But why does that warrant a new trial?
It warrants a new trial here, Your Honor, because this boiled down to a credibility contest. This was someone's word against someone's word. And then you have the testimony of 3 officers testifying against Mr. Brown. There's no outside evidence, so to speak, of what happened here. There's no video footage. There's no tether receipt that was alleged. I know that was an issue that was raised during the proceedings of the case. But this was boiled down to a credibility contest. So you have 3 police officers testifying against Mr. Brown.
Yes, who fled the tether office. He fled. He didn't walk out. And they testified to the fact that he fled. He ran as fast as he could away. And so that's not a credibility contest with respect to that. It's what he did. And they got up and testified to it. I think he said he just walked out. But again, it was up to the jury to make that determination.
Yes, Your Honor, agreed. But that is what the officers testified to. But that by nature is a credibility contest. You have 3 officers saying that this is what they believe to have happened, one of which, for the record, is the only person who saw him actually leave the area and go towards the Sally Port door. Then you have Mr. Brown's testimony that he did not run. You have Mr. Brown's testimony that he walked. And so we have there's no video evidence or anything to the contrary. So it really is a he said, she said in this instance.
But the testimony was he went out the door where he shouldn't have been going out.
That's correct. And Mr. Brown never denies that door was not one that, he never says, oh, I thought I could go through that door and turns out I can't. The issue was whether he left after he found out that he had a positive test or not. And so he is alleging that he did not run as the 3 officers alleged. However, that is their testimony. And so in this instance, it is a credibility contest, and it was up to the jury. That's correct. But such testimony as this when the prosecutor is up there saying during cross-examination and additionally during closing argument, which is the last thing the jury is going to hear before they deliberate, that Mr. Brown is a liar. It is pretty damning in this instance. Finally, Your Honors, with respect to issue 2, the failure to instruct on the prosecutor's burden of proof as it relates to the lawful arrest or detainment of Mr. Brown. The instruction specifically did not instruct the jury that that the prosecutor must prove beyond a reasonable doubt that that particular officer or deputy was acting within his legal authority.
Well, the trial court said a great deal about that. It certainly didn't read the instruction, and you're completely correct about that. But the trial court said not only that you had to find that, the jury had to find that, but also it explained the circumstances of the lawfulness of the act here, I think.
It did, the instruction did say, and that's true, that the parties did take the time to talk prior to deliberations and agree that the instruction should have something with respect to, because this wasn't an arrest for a criminal charge, so to speak. It was an arrest because of a probation violation. So they cite the statute, but they are never instructed that the prosecutor must prove beyond a reasonable doubt that this was a lawful arrest or detainment. And that is especially necessary given that the whole issue here was whether or not Mr. Brown actually believed that he had a positive drug test and that he was being lawfully detained. And so when that's the entire subject of the defense, it was a very important instruction here that was omitted.
Can you remind me, did they actually admit the test result?
No, Your Honor. If there are no further questions, I'll reserve my remaining time for rebuttal.
Thank you very much.
Thank you. Mr. Morton, are you representing the people in this case?
Assistant Attorney General Brent Morton, on behalf of Assistant Attorney General Kayla Crino, on behalf of, where are we, Chippewa County.
Okay.
Thank you. Sorry for the confusion coming in this morning too. Well, this I think is more than a credibility contest. This is a conspiracy contest, because in order for the 3 officers to have all lied and for Mr. Brown's testimony to be accurate, they would have to conspire. And so I think by calling it a credibility contest, it's not a he said, she said, or one person on one side or the other. We have it pretty well established, as you point out, Judge Feeney. He fled from there.
Right. It's
He
he
ran out
said,
the-
they said.
Yeah, well, yeah. So, I mean, I understand they're officers and that they're all in it together, but I think that the defendant's entitled to a fair trial, not a perfect trial. There are no perfect trials. There's warts here, and we've conceded some of them. And, the reality is the jury saw what was going on. He had this history of being on tether. He himself said 2 years. And yet he walks out the door that is only for law enforcement. He supposedly lights a cigarette and saunters off after they've told him you had a violation. It's just not, it's not believable. And so I don't think any of that would have mattered. With regard to the jury instruction though, opposing counsel said, well, they were never told that they had to prove the case beyond a reasonable doubt. Yeah, they were. The instruction was they have to prove these elements beyond a reasonable doubt. And at the end of that list was lawfulness of the command.
Yeah, the development of the law.
So they
in that
were
area-
instructed that.
The
I'm sorry.
development of the law in that area has been really strange because we have long said, our court, that there are 2 elements. And then we added the 3rd element in Quinn. And for some reason, it never finds its way in as a true 3rd element, even though there's no question it is a 3rd element. Now, I think you have enough here, the trial judge properly instructed, but it is odd that there seems to be this added 3rd element, and it may predate Quinn, but it hasn't been clear until Quinn came out, right?
Well,
I mean, it's clearly an element of the offense, though. You can see that, right?
yes, and I think it is confusing. I think in a lot of ways, it's an element that's determined by the court, by a judge. It's a legal argument, not really a factual argument, the
Right.
lawfulness of it.
Right. It
And-
seems strange to ask the jury whether the conduct was lawful, but still, we have to do that, right?
And I think that, yes, and I think that there's been a pushing on opposing side to say, look, the element really means that the defendant has to understand that it's a lawful command. Well, that's not accurate.
Right.
The command is either lawful or not, independent of it's not subjective to the defendant. And I think that's that's where a lot of the pushing and pulling is kind of coming from.
Well, the other
But-
thing, it seems to me, is if you're going to have that argument, this is not the right factual context in which to have the argument. I mean, if he's running away and they
Well-
yell, stop, it's hard to imagine how that's not an officer acting lawfully within the scope of duties.
Well, and even beyond that, in this case, the defense counsel stipulated to a very specific instruction that talked about the law. Look, this is what it is. This is what a lawful command would be. And the jury was given the proper tools to make the proper decision. So, you know, of course, I agree with you because you're on my side right now with that question, not with other questions or other cases.
Right.
But,
Right.
But
And
no,
by the way, and I appreciate your concession on the point that the statement on cross-examination was improper.
Yeah, it
Makes our
wasn't a
life a
question.
lot
I-
easier when you concede something that's fairly obvious.
and like I said, we're human. People make mistakes. I think the prosecutor made a mistake and prosecutor was frustrated because of the story she was being told. So I'm happy to answer any
Can I
questions.
go back to the other acts evidence? There was one piece of testimony from one of the deputies that he said he had known the defendant from various contacts going back 30 years or something like that. How is that relevant to the overall case? And isn't that fairly prejudicial for the jury to hear that this guy's been essentially, you know, in trouble with law enforcement for decades?
Well, I don't think one means the other. I mean, he has had contact with him, but that doesn't mean that the defendant's been in trouble. If you grow up in a community with somebody, you've known them for long periods of time. I think it does go to identification and these officers laying the foundation to say, yeah, we know who this is because I've known him for 3 decades. It's a small town. And yeah, I've met him in the course of my work, either on the street or maybe he's been a victim, you know, that we didn't talk about. It's kind of like the case of the unpublished case was attached of People versus Bowman. They didn't talk about how they knew the context. It's just, I've known him for 30 years. That's him. That's the person that ran out the door. So I don't agree that the bad acts were there. I don't agree that the natural outcome is that, hey, that must be a bad thing. Particularly, I live and grew up in a small community. I have a lot of contact with law enforcement. Either, you know, they're at the school at different events, they're doing donation work. And yeah, and they're pulling people over and they're taking complaints and they do a lot of things in the community besides just arrest people. They have a contact with a lot of people. So I push back a little bit on that. Thank you so much.
Just a couple of brief points, Your Honors. Specifically, while it is true that the jury was instructed as to the elements of resisting and obstructing and was told at the outset, you must find beyond a reasonable doubt. Again, there is a specific element as required by Moreno and its progeny that requires that the prosecutor must, quote, the prosecutor must prove beyond a reasonable doubt that the arrest was legal or the officer was acting within their legal authority. It is up to you as the jury to determine whether the officer's actions were legal, according to the law as I, the judge, have just described it to you. And so it is a factual question for the jury as to whether or not the officer had the legal authority to detain Mr. Brown, which was Mr. Brown's entire defense, whether or not he believed he was being detained as a result of a positive drug test and whether he was free to go or not. Finally, the prosecutor does speak to some of the prior bad acts testimony as maybe going towards identification. Identification was not an issue here. If this was being admitted to show the identification of Mr. Brown as the defendant, it would have been submitted as 404B evidence to prove identification as an outside 404B purpose. Also, the officer specifically said that they had gotten to know Mr. Brown or met Mr. Brown in the course of their work. And it is a very fair inference for a jury to assume that that means in the course of their police work.
But just to be clear about this, I think Judge Karobkin is correct that your best point there is the testimony from Deputy LaCrosse, right?
That's 100% correct, Your Honor.
Right,
Yes.
because the other two,
The 30 years.
The 30
Yeah,
years.
yes.
That's correct. And that, you know, in tandem with the two other officers' testimony really prejudiced Mr. Brown at trial. And thus, Mr. Brown is entitled to a new trial. Thanks.
Thank you very much.
Thank you so much.
Okay, that case will be submitted. we're going to go back now and recall case item number 1, docket number 366332, People versus Gerald Lee Arbuckle.
Hi, judges. This is Stephanie again. I am trying to promote him. He is in there. Here he is.
There we go. Mr. Arbuckle, can you hear us?
I can, Your Honor.
Okay, well, I don't know if you were able to hear our introductory remarks. Before we start with your argument here, Mr. Arbuckle, I just want to let you know we're familiar with your case, the facts, the legal issues. So please consider us familiar with everything. And if there are particular items that you would like to highlight from your brief, please do so. And at this point, I'll turn it over to you for anything you'd like for us to know.
Yes, Your Honor. Thank you. I would like to say that I believe we can handle this case with relative expedience. If the Attorney General would like to stipulate to a remand for rehearing on the original 6500 motion from 2022, to be clear, because there was the first one from 2016, because the brief is perfunctory. I've tried to file several items with this court. Unfortunately, the clerk rejected them, saying that I was represented by counsel at the time, when in fact I wasn't. But the Attorney General has already conceded.
Mr.
Yes.
Arbuckle, can I ask you a
Yes.
question?
Yes, sir.
There's a certain irony here that
Yeah.
you want to go back for a resentencing hearing because you weren't represented by counsel, but you fired your lawyer on appeal, and here you are representing yourself. If we send the case back for a new sentencing hearing, do you want counsel to represent you?
I tried to retain counsel, and counsel would not even talk to me on the telephone unless I had a reversal in the circuit court. See, so they didn't want to represent me during the 6500 motion, but they would represent me in the circuit court itself.
Well, it seems to me, Mr. Arbuckle, you have a good argument that you're entitled to a resentencing hearing because you were deprived of the right to counsel, and to the extent that the judge determined that you had the right to represent yourself, which you do, you weren't warned of the risks. So if we send it back, what do you want to do? Do you want?
Well, I do agree. Yes, I do agree that I was entitled to resentencing. That's what okay, so to be clear, to wipe the slate clean, to understand this, I filed a 6500 motion in 2022. Unfortunately, I believe that Mr. Zavolking, because we have our own issues and won't burden the court with it this time, but unfortunately, the attorney that was attempted to be appointed for the 6500 motion, the judge basically circumvented that and said, no, you're going to get resentencing. And I understand in my initial, in my 2022 6500 motion, I requested resentencing. And it appears that that is all I asked for. However, having experience with this court, having previously just summarily denied my 2016 6500 motion, which essentially raised the same issue. However, Stovall hadn't been decided yet, so I was raising like the Miller issues. It was denied summarily. But to be clear, yes, I seek resentencing because I'm entitled to that by Stovall. However, I wish to use the very brain science that was articulated in Stovall, originally articulated in Miranda versus I mean not Miranda, but Miller versus Alabama. Yeah, right, Alabama. And to say that my statement, which was given as a juvenile, was and under the totality of the circumstances, should have been suppressed. And now, as an adult, yeah.
I want to just go back to Judge Yates's question, and I'm trying to see if we can just kind of get a yes or no answer to this. All right.
Yeah.
If you are sent back for resentencing, do you want an attorney appointed to represent you? Yes or no?
Well, yes, if I can't retain counsel.
No. Because the judge explained to you that you had three options. You could represent yourself, you could have the court-appointed counsel, or you could retain your own counsel. You didn't retain your
Right.
counsel, and you decided to represent yourself before. So let me ask another question to try to get this taken care of. If you are sent back for resentencing, will you accept appointed counsel?
Provided they don't have a conflict of interest, yes.
And how would they have a conflict of interest?
Well, Mr. Pfeiffer, who they attempted to appoint, was in fact retained just prior to me filing my 6,500 motion. He was one of the attorneys that said that he would not represent me.
Okay. So that's what you would say. So anybody who was appointed to you before, those are the people who have the conflict of interest. Is that what you're saying?
There's a number of attorneys in that county that have a conflict of interest. I've been incarcerated for 32 years. I have either personally retained or had a third party retain or contact to retain nearly every attorney in that county. And they've all demonstrated they have a conflict of interest as having personal ties to Judge Kowalski, Judge Black, Prosecutor Grankovich. In fact, as the record shows, this case was, even though, and this is the thing, is that even though my 6,500 clearly said that I wish to represent myself during the 6,500 hearing, which was never provided, it was circumvented, and I would like to discuss that if your honors would let me, it was sent to now private attorney Dennis P. Grankovich, who in fact was my original prosecutor. And in fact, Judge Black on this case, which I asked this court to remand it to the court to a different judge or a different circuit entirely, because Judge Black has a conflict of interest. He was in fact the prosecutor in this case in 2016, to be clear, not during the trial, not during my trial, but during the first initial 6,500 motion, which Judge Mack, Judge M-A-C-K, he denied summarily. And Judge Black had now Judge Black on this case, who is the previous prosecutor that now has a conflict of interest. He was the original investigator and prosecutor of Judge Mack, M-A-C-K, during the 2016 original first 6,500 motion. And he got him removed from the bench for judicial misconduct.
All right, but
so
let me also ask a question, sir. Are you
Yeah.
trying to say that on resentencing, you get a chance to go back and re-argue your 2016 6,500 motion? Yes or no?
Yes, because I didn't actually just ask for in the 6,500 motion, I asked for a hearing on the 6,500 motion. So this is the argument I wanted to raise to this court. Okay, this is arguably issue 5. However, the Attorney General rightfully says that issue 5 has no jurisdiction with this court. I agree. I mean, technically, it would actually have to be raised as a complaint for superintending control. I argue that in as much as the Attorney General here concedes to claim 1, claim 2, 3, 4, and claim 6 are moot because they should be addressed by the lower court in the first instance. That should be, they're all moot issues. Claim 5, moot. Claim 5, I'm sorry. Yes.
If you get a resentencing hearing, you can raise all the issues that you could raise at sentencing.
I understand that, but I'm trying to raise more than just resentencing, sir. That's what I'm trying to articulate. Claim 5 argues that the 6,500 motion was not heard, and still to this day, it is still pending. Arguably, as much as I'm sticking my foot in my mouth, this court does not have jurisdiction over this entire case. That's why I tried to say this from the beginning, is claim 5 is arguably the be-all, end-all issue. However, it wasn't articulated properly. And arguably, it's not even a claim of appeal. It is a motion for superintending control or a complaint for superintending control. So if anything, I would ask leave of this court to reframe this entire appeal as a complaint for superintending control.
Mr. Buckle, you seem to be trying to snatch defeat from the jaws of victory here.
I understand that. I do get it.
I just don't
I
understand.
know I have reversal on resentencing. I agree with that. But what I'm trying to articulate here is that I mean, just plainly and simply, the circuit court has already viewed my case as a first-degree murder case when in fact it is second degree. The circuit court resentenced me to 37 to 60 years as if I had first degree. Before I lose the thought of that, is that in its preamble, if you will, to the decision, if you will, because there is no written decision and there's arguably no verbal decision on the 6500 motion. The trial court articulated that that it was frameworking, or in the very least, if it wasn't, there was actually I think it was during sentencing, the trial court frameworked my sentence of 37 to 60 under Stovall by saying, well, that there's two jurisdictions in Oregon, which, you know, what he really meant was that there was two separate categories of resentencing in Oregon, one for juveniles, one for adults. And then he proceeded to use the one for adults by trying to claim that my sentence was proportional. And I understand if I'm granted resentencing now, yes, that can be brought up and say, hey, don't do that again. In as much as claims 2, 3, 4, and 6 can be said, hey, Your Honor, don't do that again. But if this court answers them without granting the defendant relief, the court will then allow the trial court to commit those same offenses again, the same mistakes again, with or without counsel.
Okay, I think that's very well put, and we understand those arguments. So I think what we're going to do now is have the other side do their argument. But Mr. Arbuckle, you'll have a chance for rebuttal after that.
I appreciate that, if I may, so that way the Attorney General can answer it.
Sure,
to be clear, okay, yeah. The original 6500 motion is obviously subject to MCR subchapter 6.500. We all agree with that. And the first rule is, unless otherwise provided, those rules must be followed. Okay, so that being said, with that motion not even being answered, again, it's still pending 2 years later. The only other rule that could possibly cover this issue is MCR 6.429. And as this court is probably aware, People versus Comer, C-O-M-E-R. I can find the citation if you want, but it's, you know, cited right off the rule itself. The rules literally say that the judge has the ability to act sua sponte, if you will, on its own initiative. However, the court didn't do that.
Mr. Arbuckle,
Yeah. Yes.
you would like a chance to respond to the Attorney General's arguments, correct?
Very briefly, yes, but I understand.
Hold on. So we want to give you sufficient time to do that. So let's have the Attorney General respond, and then you'll be able to have your rebuttal. All right?
Okay, thank you.
Thank you. Go ahead.
Thank you. May it please the court.
Martin.
Assistant Attorney General Brent Morton on behalf of Alpena County. I just want to highlight one issue. Obviously we conceded the first issue, but historically I've been wrong before. So if I am wrong and you're going to rule on the other issues, I do want to just point out the victim impact statement, the limitation. The judge allowed a half sibling to give a statement, a cousin. And yeah, they're not victims by definition of the statute, but the statute is the minimum of what victims are entitled, not the maximum. It's not, the statute wasn't passed and doesn't exist to shackle judges from what they can hear at sentencing. They have a broad discretion to hear what's relevant. This was relevant and it should have been allowed.
Mr. Morton, how far does your concession go? Because it seems that you recognize that we have to send this case back for a new sentencing hearing. Is that fair?
Yes.
Okay. So if that happens, presumably everybody's writing on a blank slate again. A sentencing hearing is a sentencing hearing, and Mr. Arbuckle or his attorney can raise any issues he wishes to raise at the sentencing hearing, correct? Leave the 6500 motion to the side now.
Yes. I mean, as I indicated, and he's agreed, you don't have authority over the 6500 motion.
I mean,
deal.
that's a whole
But-
separate problem.
But yes, it's a new sentencing, and that if his attorney wants to argue or he wants to argue that a different judge should do the sentencing, then that's a motion they can bring and that can run its course.
Right, and as far as that goes, this law is still developing. I think the Supreme Court's granted the application for leave in Eads. So if Eads comes down, which it will before the end of July, presumably, he'd get the benefit of that as well, right?
Absolutely, yes.
Okay, so the law at the time of resentencing will be what the law is at that moment.
I agree, yes.
Okay, that's all I wanted to know. Thank you.
That's the only comment I wanted to make, and I'm happy to answer any questions, but I know that the panel has a very good understanding of what's going on. I do want to thank you for allowing us to come forward. I think sometimes as practitioners, we forget that it's important to make our argument to the judges, and I appreciate your professionalism.
Thank you for your argument. Okay, so Mr. Arbuckle, you have a couple of minutes left on rebuttal. If there's anything in
Sure.
response to what Mr. Morton said that you think we should hear.
Sure, I'll give rebuttal and I'll allow Mr. Morton a few seconds to respond as well. And then I'll finish about the
We're
about the
not going to do that.
6,500 motion.
This will be it. So, but go ahead, Mr. Arbuckle.
Okay, I just wanted to say that with the victim impact statement, these were made by people who I don't know, never knew, arguably didn't even exist prior to the alleged offense. The victim impact statement alleges that I had threatened them this past 30-something years. I'm in prison. I have no access to internet. I didn't even know they existed, so I don't know how I threatened them. Those are in fact statements that have no bearing on the case. There's no convictions for them. They don't apply as any prior offense. I didn't get any chance to challenge them. There's a case law that literally says those can't be used. I believe that's been briefed. And to circle back to the 6,500 motion, or the 6,500 motion, what I was saying about the court rule of 6.429 says that the trial court can act sua sponte to change a resentencing, but it must be within 6 months of the original sentence. Clearly, this is 30 years later, so the judge had no authority to act sua sponte to resentence. The prosecutor did not file a motion for resentencing. Therefore, my 6,500 motion, which asked for resentencing, I concede the point that I only asked for that, but I only asked for that in the context of getting my foot in the door. I would ask this court to take judicial notice that I asked for a bond hearing. And in fact, on January 3rd, the lower court register of actions clearly says that I was there for a bond hearing. There is at least an hour missing from the beginning of that transcript where I discussed with the attorney and the court and why they've destroyed or not transcribed that about an hour's worth of proceedings. You could only guess, but I know what we talked about, and if I have to do that by expansion of the record, I guess that's what I got to do because Mr. Zavoking didn't do it. So the 6.429 clearly says that the court can only proceed with the pleadings in front of it. Arguably, it didn't have the ability to act sua sponte. I filed a 6,500.
Okay,
so
Mr. Arbuckle, we get the
Yeah.
we got the 6.429 argument. We got the victim impact argument and the counsel argument. So I think we have what we need. And I think you've done a very good job of presenting your arguments here. So I think with that, we're gonna take this under submission and get a decision out as soon as we can. Okay.
Okay, thank you, Your Honor. And I was, if I may, I'm going to submit a motion in writing for bail pending resentencing or remand, but to this court and to the circuit court.
Okay, well, we'll consider that when we get it. Okay.
Okay, thank you.
Okay. So thank you very much to both of you. That case will be submitted. All right. We are on to item number 3. Docket number 369945. People versus Marshawn James Curtis. And I believe we have Mr. Simon for a remote oral argument.
Yes, good morning, Judge. I've activated my, there's the video now. Good.
There you are, Simon. Thank you very much, and go ahead.
Thank you. Good morning, and may it please the court, Jonathan Simon, P 35596, on behalf of Mr. Curtis. I think that my brief accurately sets forth our claims on appeal, and pretty much I would stand on the brief. I just want to highlight our main contention, which was that this single count of first-degree criminal sexual conduct, which seems really to have been more in the line of a third degree, exacerbated by some minor personal injury, which aggravated the charge to first degree criminal sexual conduct. And for that one charge of criminal sexual conduct, first degree, there were 6 other acts witnesses, 4 other witnesses in support of the other acts witnesses, a sane nurse who I believe pretty much vouched or bolstered the testimony of the complainant, a sexual dynamics, sexual assault dynamics expert witness who was also pretty much there to bolster the testimony of the complaining witness, a witness who was allowed to testify of a subjective fear without any basis to associate that subjective fear to be attributable to my client. And then the refusal of the court to allow my client to present a witness from Georgia who had come to Michigan to testify, but due to scheduling problems, the matter was he wasn't able to remain in town. He had to return to Georgia due to a serious injury to his wife, but was not permitted to testify by Zoom. So we believe that Mr.
About 2 specific points. The first one is this: with regard to the other acts evidence, the prosecution says that you didn't address the fact that the other acts evidence was admissible under the statute MCL 768.27B. Now, of course, that's broader than 404B, and there's instances when evidence is not admissible of other acts under 404B, but it still comes in under the statute. Do you want to say something about that? Because first, he argues you've waived the issue by not addressing the statute, and second, do you want to explain why the statute wouldn't allow this other acts evidence testimony?
Well, yes. For one thing, I believe that it would be overkill. 6 witnesses, I don't believe is a reasonable request or allowance.
Are you arguing then that there's a 403 problem, and that's why it should have been excluded? Because even if something comes in under the statute, the court still has to do analysis under Michigan Rule of Evidence 403. Is that the argument you're making?
Yes, there's the 403. There's also the okay, as to this the propensity statute. If I left that out, it was purely unintentional. It was objected to by trial counsel. I believe that the issue was preserved, and it is all part and parcel of the same claim that this was more evidence than reasonably necessary to allow the prosecutor to proceed. I think that 6 witnesses and then 4 witnesses in support of the other acts witnesses is just, I think, overly prejudicial. It certainly outweighs any probative value.
Can I ask you one more question then, and then I'll stop asking you questions? Would you say a few words about the expert testimony from Holly Rosen? Because it seems to me this is one of the touchiest issues right now. It's one thing to put on factual support for proof in a case like this, and obviously other acts evidence readily comes in under the statute, except for the 403 balancing. But expert testimony is a whole different matter. Do you want to speak to that for just a moment?
Yes, the expert testimony, and I see this all the time in CSC cases. It's a witness who says, I don't know anything about the case, don't know anything about the complainant, don't know anything about the defendant. I'm only here to say that this is from my experience, from my expertise in the area of sexual assault dynamics, is how a person would respond or is commonly responds under these circumstances. And it seems that in essence, all they're doing is bolstering the testimony of the complaining witness. It adds no value to the claim that this specific act happened on this specific date involving this specific complainant and this specific defendant. And to add that in, I think it is irrelevant and prejudicial and harmful to the right to a fair trial. And I get that, you know, in some cases where I've seen reversals, basically it's only because there's a mistake in the questioning or the response, which pretty much acts as a fact finder and leads the jury to believe that assumes the role of the jury in finding the defendant guilty. And even though that didn't occur here, the result should be the same.
Can I stop you for just a second? Because I want to know whether you think Thorpe is dispositive here. Thorpe obviously was a case involving expert testimony about a child witness. Do you think Thorpe controls the outcome of this case? And if it doesn't, how does it bear upon our analysis?
Well, yes, even though they do not come right out and say, give an opinion or act as the finder of fact and suggest to the jury what their verdict should be, they do nevertheless, I think, maintain that same effect in a backdoor manner by basically saying that everything you're going to hear other witnesses say is basically proof that you know, from my experience, that this did in fact happen.
Are you saying that under Thorpe that it applies in cases not involving children? And you can never have someone come in and explain why there might be a delayed disclosure or things like that?
Absolutely. I don't think it should ever be limited to a specific class. I mean, it involves a charge more than the age or the complainant, and the effect would be the same, whether it is a child, whether it is an adult. I don't really see the difference there. The fact is that they're still doing what they should not be doing, and that is to create this role of a fact finder and suggest that they are in a superior position to judge, and the jury should believe that the client is guilty based upon their expertise in the field of sexual assault dynamics.
But do you think that the testimony here by Ms. Rosen was the equivalent of the testimony by Mr. Cottrell and Thorpe? He was the one in Thorpe, correct?
Well, no, they didn't. She didn't come right out and say, you know, that this did happen, that this that there, but the effect is the same, because even though.
Oh, wait. So, okay, that's the point I wanted to clarify. So you are saying that even if it's not, even if the witness is not doing what Mr. Cottrell did in Thorpe, so they're not going that extra step to say, I believe them, children never lie, all the rest of that, that they cannot testify to anything with respect to assault, sexual assault. This is oftentimes what happens. This is how oftentimes victims react. Sometimes there's delayed reporting. Sometimes there's this, sometimes there's that. So you're telling me then that if your argument is that no one will ever be able to testify regarding anything regarding sexual assault because you believe Thorpe and Mr. Cottrell's testimony wipes out everyone else's, even if they don't vouch for the witness or the complaining witness.
Yes, because the effect is the same. They're put up there to say, I know better. I'm an expert. This is my field. I know everything there is to know about sexual assault dynamics. And this is how a person reacts or normally reacts, or in my experience, I've seen the reaction. And then the prosecutor can therefore weave into his argument, well, she did this and she said this, and the complainant testimony and the other act's evidence testimony is all consistent with what Ms. Rosen says would normally happen, therefore you should believe that it happened. And even if they don't commit the offense that Mr. Cottrell did in that situation, the effect, I think, is the same. There is no difference. They're doing the same thing. They're just not asking that one question that triggered the reversal in Thorpe.
Anything else, Mr. Simon?
Yes, given that, and I began by stating that I think that this is really a third-degree criminal sexual conduct case, and that there was minor aggravating personal injury which elevated it, we believe that the sentence at the very top of the guidelines would be unreasonable.
And what is the under Ventor, you're supposed to demonstrate that there's something unusual or rare about the sentence or about the case to justify a disproportionality finding. What is your argument about what's unusual or rare about this case?
That it is basically a third-degree criminal sexual conduct case, and the top of the guidelines for first-degree criminal sexual conduct, we believe, in this situation would be unreasonable.
I don't think we have any other questions, so we'll turn it over.
I mean, yeah, just briefly, the under Milborn, you look at the offense and the offender, and despite what you may think about the offender, the offense was not at the top of the guidelines, and I think that's what triggers the Posey argument.
Gotcha. All right. Thank you. We'll hear from the FLE.
May it please the court, Jerry Schrotenboer, Ingham County Assistant Prosecutor for Plaintiff Appellee. Let's start with the first issue. Yes, it's waived. You cannot find it in the brief. And I have, I cited an unpublished case. Well, here's a published case.
Sorry, what are you saying is waived because it's not in the brief?
Okay. The first issue.
Statutory basis for admission?
Yes, the statutory basis for the admission of the other acts.
Right,
Okay.
768.27B. Okay, thank you.
B, that's correct. I cited an unpublished case, and here is a published case. Stewart, Stewart, versus IHT Insurance Agency Group. Yeah, I know, it's not that easy to find. 990 F 3rd, 455. Pages 456 and
But just to be
457.
clear, this is a civil case from a U.S. Court of Appeals.
Yes,
Okay.
yes, it is. Sixth Circuit.
So I agree that the 768.27B issue was not in defendant's brief.
Yes.
But even if that's waived, don't we look at 403 for everything?
Yes, you do on that. Well, actually, no, because the whole issue is waived.
But
He's saying
whether
403.
the admission is under 404B or the statute, there's one more hurdle the prosecution has to overcome. They have to, if they get an objection under 403, they have to show that it's not substantially more prejudicial than probative, right? So. no
And
matter-
403 was argued, I think, in the brief.
Right.
Yes, but he's not arguing on appeal that 403 is violated under the statute, which is broader than 404B and the
Right.
other
but-
side.
but
He's not
still-
arguing that.
Right,
So
but the 403 analysis, I think Judge Karobkin's point is accurate. The 403 analysis at the back end of either 404B analysis or the statutory analysis is the same. Doesn't matter what the basis for admission is. There's still that opportunity for the defense to object that it's substantially more prejudicial than probative. And that analysis doesn't differ at all between the statute and 404B. right?
actually it does,
Why?
because the statute is broader. And under the statute, it is more probative than under 404B.
Oh, I see. So what you're saying is the statute makes it more probative.
Yes, and of course, substantially outweighs the probative value. So therefore, under that rather narrow analysis, it's waived. Now, what the Sixth Circuit case says, when a district court provides two alternative grounds for its decision, the losing party must challenge each ground on appeal to change the outcome. It does no good for a track and field hurdler to clear just the first hurdle in a race and then sit down on the track. Yes, you can see why I like that one.
It's a colorful example.
So
Anyways, let's go to 403.
I mean, I understand. I mean, I think I understand why the Georgia case is like, that seems, I get the connection there. What is the, and I went back, the trial transcript, the trial judge basically sort of just, it was a little incoherent why he thought all of the other evidence under 404B, put aside the statute, but the 404B evidence came in. What is the connection between all of those other acts outside the library, that kind of thing?
It shows what the guy does.
Okay.
It's not 404B, but it is under subsection B, or under the statute B.
Well, the Georgia case was admitted under the statute,
Yeah.
and one of the other situations was admitted under the statute. But then the prosecutor, as I understand it, the prosecutor went 404B on all of the other acts.
Oh, they all show his MO. It all shows, it all comes down to the victim's credibility. She testified after the rape, he threw up, and then he went over and masturbated. Now, men know that after having sex, masturbation is not normal. However, given that this guy likes to masturbate in public anywhere he goes, all of a sudden it becomes a little bit more credible. I'll give you a historical example. The Phoenicians went around Africa 2,000 years before the Portuguese did, and they published it. And a Greek took a look at it and said, yes, I think they did that. However, there's one thing that doesn't make sense. They said that after a while, they noticed that the sun was to the north rather than to the south. Well, we know that it's always to the south. Well, that's true if you're above the equator and above the Tropic of Cancer. It's always to the north. However, now we know that, to the south. Now we know it's to the north if you get below the equator, and particularly if you get below the Tropic of Capricorn. So, of course, we didn't use that example at trial. Of course not. But here it's a nice example. And the main question, what he's talking about now is, oh, it's overkill. Okay. The Smith case that I cited in my brief.
Sorry, I just want to come back to
Sure.
There's no question. It's not like this is a case of mistaken identity, right?
Yeah, that's
this
true.
is a question of whether there was consent,
Yes.
essentially. And so you're saying that if the victim's testimony is more credible as to his peculiar activities after sex,
Yes.
then the jury is more likely to find her credible about whether there was consent. Is that?
Yes.
Okay,
That
got
is
it.
exactly the point.
All right, got it. Thank you.
Okay, the Smith case that I cited in my brief, the defendant was on trial for something like a felon possessing a firearm, and he refused to stipulate to a prior felony. So all 11 of his priors came in, and the Sixth Circuit affirmed, saying no abuse of discretion. Now, that's quite a bit. That's a lot more than happened here. Anyways, moving on to Holly Rosen. I have an unpublished case here that came out February 19 that dealt with this issue. For counsel, People versus Bates, 371-525.
Well, we'll look it up. We'll look it up. Thank you.
Sure.
So this was a peculiar situation, and we haven't read Bates, but this is a peculiar situation because this is not Rosen's direct testimony, as I understand. This came up in cross.
Which kind of reduces the problem.
Would there be a problem if she had said these same if the prosecutor had elicited these same comments, which essentially were, I've never met anyone who wasn't telling the truth on something like this.
That same thing came out in Bates.
Okay.
And this court didn't have the slightest problem with it. And of course, that was about 2 weeks ago.
Because it came out on cross-examination?
No, that came out on direct.
Oh, okay. So in other words, this case is an easier case than Bates.
Yes, that's correct. And in fact, we don't have an objection here, meaning we need plain error review, which is very, very difficult to show. And given the Muniz case, which completely wipes out defendant's claim that, oh, no, none of these people should ever testify, and Muniz is still the law, cited in my brief, that takes care of that. Now, moving on very quickly on his claim of subjective fear, well, the cases say that you are allowed to bring out a subjective fear, even if you can't connect it to defendant, if it explains the defendant's changed testimony. Cases from Michigan say that. And, witness from Georgia, the judge did not say, I will not allow him to testify. The judge merely said, I want him to testify here in court. And let's see now, when the prosecution asked to present witnesses from Zoom, defendant said, absolutely not. No, 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 it has to be here.
But that's a confrontation clause problem. And it
That is
applies
correct.
exclusively to the government.
That is correct. But it is a bit, that's absolutely correct. There's nothing even-handed about the confrontation clause. That is correct. But it's a bit much to complain on the one side and then want the same thing on your side, especially when this guy very blatantly violated the judge's sequestration order. And there's no abuse of discretion here. If you have any other questions, I ask the court to affirm.
No.
Thank you.
Very much.
Yeah.
Mr. Simon?
Briefly, I may have misunderstood, but I think counsel said that the subjective fear was to explain the defendant's testimony. I believe it was to explain the discrepancy in the witness's testimony. He had initially said that he had picked up the complainant at her house after the complainant testified that it happened at a bus stop, he was recalled. And that was why he explained why he was inaccurate about his initial assertion as to the location where he first encountered the complainant and took her, I think, to the hospital. So it did not have anything to do with Mr. Bates, Mr. Curtis's testimony. This was still in the prosecutor's case in chief, I believe, and but it rather goes to the testimony of the witness. And I think that the use of this subjective fear, which is totally unrelated to Mr. Curtis, was actually kind of used instead to suggest that there was some kind of a consciousness of guilt. And so for that reason, I believe that there is more to that subjective fear than simply saying that, well, it's been allowed in other cases. It shouldn't have been allowed in other cases, and it certainly shouldn't have not have been allowed here.
Well, when you say consciousness of guilt, wouldn't that require the jury to infer from the testimony that the defendant or someone over whom the defendant had control did something, made some sort of threat to the witness? I mean, the witness doesn't say that. The witness just says basically, like, I'm being very careful because this is kind of, this is scary.
Well, I think the witness is stating that for some reason he felt that there was a reason to be afraid. And the natural implication is that the fear would be from that of Mr. Curtis or those acting on his behalf. And there was nothing to suggest that any of that was accurate. And for that reason, none of that testimony should have been permitted. This was a preserved issue, and we believe that it was fatal to the people's case.
Anything else?
Nothing further.
Okay. Thank you very much. That case will be submitted.
Thank you.
Calling the next item is item number 4, docket number 367414, People versus Jerome Randy Rogers.
Well, good morning.
Morning.
Mitch Foster for Jerome Rogers. So I believe I laid out everything, all my arguments pretty clearly in the brief and in the reply brief, but I would like to add a few things. First of all, I would ask that you take a strong look at the arguments I made in the motion hearing on the motion for a new trial, because that gets into stuff that wasn't included in the briefing. But I will highlight some of that as we go forward. Now, for this case, we don't know that the defense attorney agreed to the prosecutor's selected snippets of defendant's statement to the police.
Well, we know for a fact that the entire interview didn't get played, correct?
Yes, that is correct.
So presumably, if somebody were unhappy, they could just raise an objection under the rule of completeness, and the court at least would have had to wrestle with it and may very well have allowed the entire statement to be played, correct?
Yes, yes. And that was my argument on for ineffective assistance of counsel.
Right.
That the defense attorney should have done that, but we don't know why.
But here's the problem that I have with this. It seems to me that there are things that the jury didn't hear that would have been damaging to the defense. Can you at least agree with that? Even though there are some things that would have been beneficial to the defense, perhaps.
Well, Judge Yates, that was the prosecutor's argument at the motion hearing, and as well as the trial judge's
Right.
conclusion. But I strongly disagree with that.
Okay.
And I put that argument in my briefing.
Right.
That if
Right.
if this was a drug case that he was prosecuted for, and it'd be a great strategic decision for the defense attorney to exclude any reference to another drug case.
Sure.
So but this is a murder case. And I also wrote in the brief that there was all sorts of testimony that Jerome had been at the decedent's house 100 times, and he was that he knew about the
Oh, yeah. I
the
mean,
drugs.
I think
He was a regular drug user. He had a cocaine habit, and he said he had a hard time kicking it, but he did.
right.
He had all sorts
Right.
of drug history.
There's no dispute that these people all knew each other and known each other for a very long time. Yes?
Yes, that's correct.
So, right. And I think that the drug relationship was, I think, well established as well. That your client was buying small quantities of drugs from the people in the house, right?
Yes, yes. But Judge Yates, that really highlights my point that what's another drug case? Those are all the times where he was using drugs and he
Right.
wasn't get caught. What if he got prosecuted for one of those for drugs?
Right, sure.
What's the big deal? Because everyone knows he's a regular drug user for years. But why is it such a problem if he has one case in Saginaw that he actually wasn't even, he went a long explanation how he wasn't even guilty of that case. It was just a charge and he missed a court date. And when you put the whole thing in context, the interview was 30 minutes before they even questioned him about the murder. And when he got picked up, the U.S. Marshals and the Chicago police said, oh, you missed a court date for a drug case.
Oh,
So they didn't say anything about a murder. So
Right,
they were
right,
being deceptive,
right.
which they're allowed to do.
If this were the first case in history where they suspected somebody of murder but picked them up on something else to hold them,
Right.
this happens all the time. I mean, they've got the easiest thing in the world here. They've got an outstanding charge. He's not around. He's taken off. The easy thing to hold him on is that. I mean, the Marshals Fugitive Task Force doesn't get involved in picking people up for dumb little drug cases.
But the jury,
That's not why the Marshals were involved.
but I don't think the jury knew that. And,
No, I get that,
you
but
know,
I mean, but
and that's
the-
critical.
Right, the idea that the real crux of all this was the drug charge, which I think is a 4-year felony, right? I know he's a fourth offense.
Well, it could have been delivery, which possession with intent to delivery, it could have been 20-year, but either way,
Right,
I think when the jury, if they would have heard it, they would have understood that the marshals could have been involved in the war on drugs and delivery of dangerous drugs. Maybe there was fentanyl, who knows? There's stuff that the marshals realistically would have been involved in, at least in the jury's mind. Now, a criminal defense practitioner probably said, well, the marshals wouldn't be involved in a local case out of Saginaw on a drug. But the jury doesn't know that because they're not in the practice. They don't really do that. So I think it was very important for that to come into evidence. And it's just, do you have anything
But
more? on that?
so it sounds to me like you're not even conceding that it was a strategic decision by the defense attorney what to play and what not to play. Because it sounds to me like the prosecutor and the defense attorney sat down and reached an agreement about what was going to be played and what wasn't going to be played. There's no way that decision was made by the prosecutor on the fly during testimony, during the trial, right?
We don't know.
I mean, that
I agree
never
with
would have
that,
happened.
Judge Yates, but we don't know whether the defense attorney and the prosecutor sat down and hashed it out and said, okay, these are good, or whether the prosecutor just said, this is what I'm gonna play, and the defense attorney maybe got an email and looked at it and never responded. We don't know any of those details because we didn't have a Ginther hearing.
Right, but just to be clear, though, I mean, if counsel had been essentially surprised by what was being played and what was not being played, it would have taken nothing more than an objection under the rule of completeness, Michigan Rule of Evidence 106, to get it all played, I presume, right?
That's correct, yes. And that objection wasn't made. So, and I think what you're getting at is we don't need a Ginther hearing because it's apparent on the record whether there was an objection or not. But I think at this point, we have to weigh the, if it was a strategic decision, whether it was sound strategy. And that's the Trachtenberg case and some other cases. It can't just be trial strategy. It's got to be sound trial strategy.
But even if you're going to go down the path of ineffective assistance of counsel, you still have to show prejudice. Why is there a reasonable likelihood that the outcome would have been different? Because I'm just not seeing that at all.
Well, that gets to the stuff that I didn't put in my brief. And we'll get to that. If you look at the transcript of the day before the last day, the day before the verdict, the jury was sent out to deliberate, I think around 11:30, so midday. And they deliberated till 2:30, and then they wanted some to look at the videos and everything. They came back at 4:30, right before the end of the day, and they said they wanted to hear a defendant's statement. Okay, so the prosecutor played the selective parts, laid out all the important parts to put everything in context, and played it for the jury and finished around 5:02 p.m. at the end of the day. And then they sat with it overnight. They come back the next day and they gave a note like, can we play the when we got caught part again? Which was only like 6 or 7 seconds. And the jury foreperson, the lady, juror number three, said, they asked, can we play it again? Yes, please play it one more time. And then the judge said, is that enough? And the foreperson said, yes, that's sufficient, something along those lines. So not only did they request to hear the video during their deliberations the day before, they focused in after sleeping on it and reconvening in the morning and asked, can we hear the critical part about when I got caught? They had no idea about this 30 minutes that went on. And then he said, oh, you mean when I got caught? When the marshals told him that he got caught for a drug case. They had no idea what that meant.
But leave that aside for just a moment. Assuming the dying declaration was properly admitted, how could there be any reasonable probability that he wasn't going to be convicted when you have somebody who knows him well, who says it was Chicago, and then follows up and says his name? This is somebody who got shot by a person who knows him and identifies him. And how do you get around that?
Well, Jerome himself, in a standard for a brief, challenged the dying declaration. So I'll leave his argument to the
But
court to be
let's
submitted.
let's
But if
assume
it
the
did
dying
come in-
declaration was
Yeah.
properly admitted. How do you get around that?
Well, what I would say is that the name given was Chicago. I listened to that recording multiple times. It came out, I think in the prosecutor's closing argument, she said Chicago Rogers was what was on the tape. But if you look at that tape, Rogers, you can't hear the word Rogers on that recording. So that would have been the prosecutor misconstruing the evidence. So, and there was evidence also, I think the probation officer, the defense attorney put that a probation officer or someone from the Department of Probation saying that she's had at least 4 people that named Chicago.
But I
And-
thought that the name Rogers came out not immediately after the word Chicago, but there was some time and then she made the statement about Rogers.
I disagree, Judge Feeney. I did not hear that. I listened to it multiple times. I would urge you to not rely on the prosecutor's closing argument. If that's your recollection of what you heard.
I'll go back and.
Yeah,
look
Well,
at it.
your point, I take it, is that not that this was insufficient for any jury to use for a conviction, but that the fact that there was this error, alleged error regarding the when I got caught statement, that there's enough here to indicate that it had some effect on the jury.
Yes, Judge Kropkin, that is correct.
I mean, you don't have to show that there's prejudice. You don't have to show that the remaining evidence is insufficient to support a conviction. You just have to show that there's an indication that that there was an effect on the verdict.
A reasonable
Here-
probability.
What's that?
Right,
Reasonable
just a
probability, yes,
And
right.
that's less than a preponderance of the evidence, as the case law
And
says.
here we have something that's a little unusual, which is not just that, I mean, it seems to me we usually use how strong the evidence is as kind of a proxy for whether the jury was affected by the error. Here, we actually have something a little unusual, which is that the jury specifically asked for the when I got caught tape to be played to them again right before they reached their verdict.
So that leads to a point that I was going to make earlier. So they get that clarification. They're probably saying, well, what did he say? What did he mean? They're talking to themselves. What did we mean when I got caught? Let's hear that again. And everyone's probably said, yeah, let's hear that again. They hear it again. They deliberate. Less than 45 minutes later, 30, 40 minutes later, they decide he's guilty.
And the
that's it.
prosecutor had said.
That's the last thing they asked about.
And the prosecutor had said, I want you to focus on when I got caught because that shows consciousness of guilt.
Innocent people
And
don't say
innocent
that.
people don't say it. And the prosecutor knew that there was this other drug case that it may have been, that the statement when I got caught may well have been referring to. And the jury had no idea. They just
Right.
had no. So when they thought about does when I got caught mean consciousness of guilt, the only reference point was the murder.
Yeah, and I think that's critical. That goes to the prejudice, that they honed right in on the prejudice. This is probably the final straw that to tip it to the guilty versus not guilty. We want to hear that again. They heard it. They came back a half hour later with a guilty verdict. But what I would say about the prosecutor is that, like you said very correctly, Judge Kropkin, she knew and the jury didn't about the drug case. And she exploited that.
But that goes back to what Judge Yates, I think, was discussing about ineffective assistance of counsel. I mean, why wouldn't you then, as defense counsel, insist on the discussion regarding what the marshals had told them coming in as well? It doesn't make sense that they would not have.
I agree 100%, Judge Feeney. That was ineffective counsel. And I think that would be a reason to grant a new trial. It's definitely a reason. It's a combination of prosecutor misconduct and ineffective assistance of counsel for not objecting at the closing argument, as well as allowing it to come into evidence in the first place. And let me say this. So say the whole recording was admitted, okay? Just for the sake of argument. And then the prosecutor during closing argument says, innocent people don't say that when I got caught. Well, that's still a stretch because in the context, it's obviously referring to the drug case.
But at least the jury could make
But
that
at least the
determination.
jury, exactly,
Right.
the jury can weigh that, and then the prosecutor looks bad. The jury's thinking, well, she's trying to mislead us. We know that's about the drug case, and they're going to hold that against her credibility. But here they couldn't hold that against her. She took advantage of it. She exploited it, and it led to a conviction 30 minutes after they heard it for the final time.
So you're saying that we have to assume that the jury completely disregarded the dying declaration?
I disagree with that, Judge Feeney, because I say, and I listened to it multiple times, turned it all the way up on my computer. I did not hear the name Rogers anywhere in that dying declaration. If you can hear it, I stand corrected. But if they said Chicago, You look at the totality of the evidence in reasonable doubt. There's multiple people nicknamed Chicago. We had the testimony from the probation officer, at least 4 of her probation officers
Yes,
were
but,
nicknamed Chicago.
but not
So
with
that
the-
could have been another Chicago.
but not with respect to the people who were coming into the house. People who are regularly frequenting there.
Oh, we don't know that. There was no testimony that there's no other Chicago that I recall. Who knows how many people she knew that necessarily weren't even coming into the house. I mean, maybe she knew someone that wasn't a regular visitor at the house that just she knew from somewhere else. Maybe this person had people mad at her, these 2 ladies mad at her, and the person was Chicago. It could be maybe she was confused and maybe someone looked like Chicago, meaning Chicago Rogers. There's all sorts of things that we don't know.
Well,
And
I
these
mean,
are all
dying
reasonable doubts that the
declaration-
jury could have considered.
I mean, dying declaration evidence is admissible, there's no question. But it's not quite the same as evidence where you have an opportunity to cross-examine for, was there opportunity to observe? Did you think it was Chicago? Did you know it was Chicago? Did you see it,
Right.
Which is not to say it's inadmissible, but it has there's a difference in what it looks like.
Right.
But I,
how
but
powerful.
I thought that the daughter who made the statement wasn't she shot from the front? I thought the mother was shot from the back. So, which would belie any ability to see anything, but I thought that the daughter was shot from the front or the side.
I don't dispute there was a dying declaration. I don't recall where I would. I
I
defer
mean,
I don't dispute
dying
that.
declarations are admissible because the opportunity for making things up is much less than in normal circumstances. You're dying. You have no idea what's going to happen to you, and you make that statement.
Well, I would agree with that in general. I wouldn't concede that the dying declaration was admissible because I'll defer to my client's standard 4 brief, but for the sake of the argument, number 1, I don't know if she knew she was dying. That's an argument that could be made to the jury. Number 2, when someone is dying and may not always think clearly, so it could be they're having some difficulty remembering and thinking clearly as they're dying, lack of blood, all sorts of things. So, and the most important point, taking it away from that and looking at the general totality of the evidence, if that was enough and they didn't need to hear that recording again, we've got the dying declaration, let's convict them. They wouldn't have even need to come back the very next day. But they heard the recording. I'm sure they discussed the dying declaration before that. They heard the recording again because they thought that was important, and then they heard it the next day.
It
Because
is
they still
so
weren't convinced.
dangerous to read something into the questions that come from the jury.
But when it's that specific,
Oh,
honing right in,
you're talking to 2 trial judges, and I could tell you stories. He could tell you stories because we talk to the juries after the fact, right? And we hear the stories of, well, everybody but this one person thought that blah, blah, blah. And that's why they had to ask the question. Everybody else was convinced, but this one person had to sit there and go through the whole book. They had to go through the testimony again. They had to look. So I agree with Judge Yates. Trying to draw conclusions on why they asked that is precarious territory.
well, I have a solution for that. This court has the power to remand for a Ginther hearing, but also has its own power to remand. We could subpoena juror number 3, the 4-person for a hearing.
Ooh,
Like, why was
boy.
it so important?
Now you're gonna try to impeach the verdict?
Not trying to impeach the verdict. I'm just trying to say, why was it so important that you wanted to hear that?
That's
But
impeaching, that's totally.
We
impeaching.
don't know what goes on in the jury room, and that's why sometimes we use the strength of the evidence as a proxy for whether an error affected the verdict. But sometimes we use other things as a proxy for whether the error affected the verdict. And one thing could be, what kind of questions came back from the jury.
Right. To Judge Feeney's point, though, as luck would have it, I was just a juror last summer. I was the 4-person. We sent out 2 crazy questions because we had one holdout who was spouting all sorts of bizarre theories. And so we had to ask the questions just to knock them down.
That's another very important point, Judge Yates, that leads me to respond to that with,
Right.
okay, say this foreperson didn't care one lick about this recording, but there was one, maybe two holdouts that said, we can't convict because we want to hear that recording again, and we're concerned about this. So maybe it was just this one. It doesn't take more than one, as you know.
As I
to-
know,
to
from experience.
to have a hung jury. And I don't have to prove, more likely than not, that it would have been a different outcome. And a different outcome could be a hung jury. It wouldn't necessarily mean an acquittal. So,
And it could be a juror that we wouldn't agree with had we been on the jury.
right,
It's not really.
but if that juror holds strong, and if that one holdout juror heard the whole recording, there's a very reasonable probability of a different result.
Can I go back to the prosecutor's the situation involving the prosecutor having this knowledge that there was a drug case and the jury not having that knowledge. It seems like a kind of an unusual situation to me. I haven't seen a case where that's the kind of situation that's before us. I know, we have cases involving perjury where the prosecutor knows there's been perjury and doesn't disclose that. That's a whole universe of cases. We have cases where a prosecutor vouching, right? The prosecutor implies or says to the jury, like, this person's telling the truth, this person's not telling the truth. That's a whole universe of cases. Do you have any cases kind of like this where there's kind of like you said, there's sort of the prosecutor is whether manipulated or taken advantage or made some sort of argument based on evidence that the jury doesn't really have access to?
No, Judge Kropkin, I do not, but perhaps this should be the first one.
Maybe that's why we're here, yes.
Yeah, but if there is, I would welcome that, maybe from another jurisdiction. But I would look at the rules of professional conduct. And if you're misleading the jury, I don't know the specific rule, but I'm sure it's in there. Candor toward the tribunal or something along those lines.
Any other things from the case?
I think I've covered everything unless there's any further questions.
I think so. Thank you.
Thank you.
Okay.
And I'll reserve whatever limited time I have for rebuttal.
Good morning, Your Honors. Russell Babcock on behalf of the Saginaw County Prosecutor's Office. Your Honors, a lot of things have been presented here today, and I'd like to, rather than regurgitate what's already been presented to the court, focus on some of those points. Number one, my take as the appellate attorney responding to this brief on appeal was that their argument about this drug offense, knowledge about this drug offense, was in the context of this audio recording that was selectively shown. I don't think there's been any, and I could be wrong, I have not looked at the record, well, any independent knowledge by anyone beyond what may have been said during the course of that interview. So I think that's the first thing. We've heard some statements about, well, maybe we should be calling it the court, we should be remanding it so that we can have jurors questioned.
We're not doing that.
I know, that's extraneous forces, questions, those are things, I'm not, without the authority from me, I can tell you, I agree with you, Judge Yates, that's entirely
I mean,
inappropriate.
that would be you talk about things that are unprecedented. That would be unprecedented and wildly improper.
But isn't it yes, I agree with Judge Yates, but isn't it the case that the prosecutor at closing argument said to the jury, I want you to focus on this statement by the defendant. And the statement by the defendant is, when I got caught. And the jury has no, and all of the discussion before when I got caught was about a drug case, not about a murder case. And the jury has no idea that there was a drug case. And so doesn't that strike you, regardless, we don't know what was in the jury's minds, of course, but doesn't that strike you as raising a question about whether the jury was misled?
Your Honors, I think how I would distinguish that would be where it was taken in the context of the trial. One of the things we've been focusing on here during questioning by defense counsel is this one particular interview. what we're glossing over, what the court has been glossing over, not actually say the court, what's been glossed over so far during the presentation is the overwhelming evidence. So we have had the conversation about the declaration. We also had the fact that we had other independent evidence, such as the comparisons of the clothes and jurors were given presentations where the clothes that were and the video still images were compared.
Gloves.
There was a lot of other independent evidence that was being presented here. So when the jury, in fact, well, the other thing that's kind of been missed here is when the jury started asking questions, and Judge Yates, I agree. Sometimes we put way too much emphasis on what jurors are asking. But the fact of the matter is, if we're going to go down that path, we can't ignore the fact that the jury also asked for other pieces of evidence to be considered prior to rendering its verdict as well. It wasn't just limited to this one specific piece of evidence. And so the way I would present it, and of course, armchair quarterbacking is what I try to, is that when you consider all the evidence leading up to closing arguments, there was more context. There was these text messages that the defendant was having with his sister, because you heard something earlier, but I heard this comment again. But this was simply a drug case, a simple drug case. Well, if the jury was presented with evidence where he's contacting his sister, and I'm paraphrasing here, I grant you, but where he's freaking out, I'm homeless, the family won't let me live with them, I can't talk to you by cell phone, I'm thinking about going to Florida. I mean, there's all these things going on here, which are completely inconsistent with just a simple drug case.
And counsel, juries are supposed to follow their instructions. And the instruction that we always give, and we repeated it at least a couple times, as I recall, is that the arguments of counsel are not evidence.
And that is very true, Judge.
And I understand that it could have had them take a look at it, but it seems that in weighing everything else plus that, I don't see it as tipping the balance.
And I appreciate that, Judge. I think you're right. I think there was a lot of evidence here, and that's the problem. That's the elephant that's in the room here. There's a lot of evidence that was supportive of this verdict. Obviously, this was a point of attack. The defense has obviously did their job by making the attack, but I think at the end of the day, I don't believe that the attack should be victorious. I think that the courts should affirm, and by the way, affirm the lower court's rulings. And unless your honors have any more questions, that's basically where we stand, your honors.
Okay. Any rebuttal, Mr. Clusper?
I did not technically rebuttal, but I did not mention the fact that part of that recording that should have been admitted was defendant denying that he did it, and he didn't testify. It's all in the brief, but I think that's critically important that we really missed out on our discussion today, that the recording of him being questioned multiple times. Well, if you didn't do it, who did it? I can't tell you what I don't know. I'm saying this on my mother. All these things are critically important for the jury to hear, especially when the defendant doesn't testify in his own defense. And for some reason, those were conveniently left out. So I think that was very problematic.
But when they play it, they don't know that he's not going to testify.
But
I mean, that's
true.
always the last point. You're like,
Right.
is he going to testify or not?
Well, that's true. But since he didn't, it becomes that much more important to put it in. I think the jury, when they deliberate, they look at the total, and it's after this defendant didn't testify. They look at the big picture. So I think it's important, and I don't think it matters at the time they heard it. They still remembered it when they deliberated. So I think I take your question, but I disagree that that was important. And finally, especially Judge Feeney, I would urge you to go back and listen to that recording of the dying declaration.
We will.
And if that's the tipping point, hopefully that'll persuade a couple of you to come to my side. And in the alternative, I would ask for a motion to remand, and we'll skip the part about bringing the jury in, just for their hearing. Thank you.
Thank you very much. That case will be submitted. All right, we are on to item number 5, which is docket number 371255. Kuwaitan Casinos Gaming versus Patterson, Earhart, Wheelbird, and Wilson. I think the first thing I need to know is how you pronounce, is it Kuwaitan or Kuwaitan or something else? Kuwait.
But I'll stipulate the Kuwaitan.
Okay.
Could I make a request before we begin?
What's that?
And I did consult with Mr. Lieberman with no objection, but I do have a in-house counsel from the Sioux tribe here to observe, mostly to supervise me, wondering if it would be okay for him to sit. He would not be participating, but wondering if it would be okay to sit.
He's a member of the bar?
He is a member of the bar.
Absolutely. Thank you.
Thank you.
We have no objection.
Yep.
Thank
Please
you.
come on up.
Yeah.
Okay.
Thank you, Your Honors, and may it please the court. My name is Daniel Barnett from Butts Along, and I am appearing on behalf of plaintiff appellant Kuwaitan Casinos Gaming Authority today. Excuse me. I plan to speak on 3 issues and then save the remaining time for rebuttal. And those 3 issues are the first being whether a former agent of an Indian tribe can be bestowed the sovereign immunity of the tribe to be used against the tribe. The second, whether there's a valid forum selection clause. And finally, and briefly, the with or without prejudice issue. I stand as to our briefing on the remaining issues, and of course, I will attempt to answer any questions that you may have if there's any as to those issues I'm not going to speak on. So I'm going to start by taking just a minute to reflect upon the ramifications of defendant's request. That is to bestow immunity that has been created to protect sovereign nations upon an agent of a nation to be used against that nation. Defendants were independent attorneys hired by the tribe and hired by Kuwaitan to represent them. They are asking this court to take the immunity that is really part of the core of a tribal nation's self-governance to use against a tribal nation.
Is there any chance at all, if your client were to prevail in this case, that a judgment could possibly wind up having to be paid by your client?
By my client.
By your client, yes.
No, Judge.
Right, because it seems to me that that sets the table for the discussion about whether this is in fact a violation of the sovereign immunity of the tribe.
Right, Judge. And to that extent, though, and I'll touch on this later, even if that were the case. So Michigan law is pretty clear on this. I believe it's the Bashir case with Kuwaitan on a former, or excuse me, the tribe on a former Michigan Court of Appeals case, unpublished. But it says and holds that a tribe waives its sovereign immunity once it commences suit. And in doing so, it waives any sovereign immunity to a direct counterclaim and
Right,
defenses.
sure,
Right.
sure.
So, and I'll get to that in a little bit more. But
Right, I mean, if they were to counterclaim against you and say you didn't pay all of your fees, obviously they could be trying to collect from you, but
absolutely.
that doesn't mean that they don't get, that the sovereign immunity that attaches typically to your client attaches to them as well, just simply because they're your legal representative.
Exactly, Judge. And so let's think about those ramifications for a second and the consequences of upholding the trial court's order. So a tribe now cannot hire a CFO, a CEO, any other agent, a contractor without the ramifications of, oh, I can't sue you if you do wrong. But it evolves. It's more than that because the state of Michigan enjoys a very similar immunity to tribal sovereign immunity, and that being governmental immunity. So the state of Michigan cannot sue a former employee now because of wrongdoing during employment? Because that's where this is going.
That's exactly what I thought of. I sit on the Court of Claims and I thought, my gosh, if this theory works, it's
Right.
going to wipe out half the docket on the Court of Claims.
Right, and I believe that reveals the fatality of defendant's position. And so does all the relevant jurisprudence. We cited in our brief defensive sovereign immunity, right? We label it as that. And that's exactly what it is. All of the jurisprudence, no matter which way you label it. And I do believe, we'll talk about this a little bit later, I do believe there are some fine points this court could make because I think that it's necessary to correctly interpret tribal sovereign immunity versus tort immunity, for example. So I think there are some differences to make. But the point is, all of the cases revolve around we are protecting the sovereign nation.
What I take to be your argument is there could be cases out in the universe, and some of which were cited in the brief, where when the general counsel of a tribe gets sued by like someone outside the tribe, and the tribe, if that lawsuit is successful, the tribe might be on the hook for paying the judgment, then tribal sovereign immunity could be raised as a defense.
Absolutely.
It's just that that's not even close to what's happening in this situation.
Absolutely, Judge. And I agree with you. In the Great Western Casinos has a quote that it says, it's difficult. Hold on. I think I wrote it down so I don't try to butcher it.
You never know when you write something that's going to be quoted later, what it might be used for. And this might be that kind of situation.
That's true, Judge. But Great Western Casinos does state, it is difficult to view the suit against the tribal officials as anything other than a suit against the tribe itself, to your point, Judge. So if, let's talk about those two types of immunities just briefly, because I think it's important. I want to make sure Michigan jurisprudence is right on this. But if we take that situation where an agent is being sued, but really to get documents of the tribe. What if the the tribe was sued, for example, on a case from 2021 that defendants were working on at the time, and that plaintiff corporation subpoenas defendants, somehow gets around the attorney-client privilege and says, we want these tribal documents that are in your records. That would be attack against the tribe. They want tribal documents. That's where the immunity protects the tribe. So it's extended to protect. But I want to make sure that the second part of that analysis of the immunity, and I believe this is where some of the courts are mixing it up, is the Davis case and its progeny state you can also, as a tribal nation self-government, do the same thing the state of Michigan does and give them tort immunity if they're acting in their official capacity. That doesn't really apply here, but I do think it's important that, that the law in Michigan is settled up on that. So given that understanding, let's break down what defendants are really asking. And I say that because they can't be really saying they enjoy the tribe's sovereign immunity. For one, we just talked about it. It's to protect the tribe, not the agent. But number two, a tribe can waive its sovereign immunity. And as we talked about, Judge Yates, when you brought up your point, the Sioux tribe, not the Sioux tribe directly, but Coaton, an extension of the Sioux tribe, a separate instrumentality of the Sioux tribe, did that when it sued in state court. It waived any sovereign immunity that existed. And the Catskill case states this very well. Tribal attorneys possess sovereign immunity only to the extent that tribal official possesses sovereign immunity. So that the extent the immunity has been waived by the tribe, the waiver extends to its attorneys. So for the first reason, we have to protect tribes. The second reason, it can be waived by the tribe, means they can't be claiming they have the tribe's sovereign immunity. They have to be claiming they have their own sovereign immunity of some kind. That's the only way that this would even make sense. The problem is there's nothing to support that.
So as I recall, your opponent first argument was actually the forum selection clause, and then they went down later to talk about sovereign immunity. So do you want to address the forum selection clause, because that seems to me it says in the contract these cases shall be brought in tribal court. So
absolutely, and I don't want to belabor this, but at the same time, you know, the little boy inside of me is really excited to speak in front of you today. So I do want to make one more point on the sovereign immunity.
Thank you for that. That's so kind.
So we mentioned in our brief, we must recall the origin of sovereign immunity. No one may sue the king without the king's consent. So I want you to imagine for a minute the king hiring a contractor to upgrade the palace, and the contractor defaulting, the king suing the contractor coming in and saying, court, your honors, your majesty, I'm sorry, but I worked for the king. He can't sue me. He would have been beheaded. And that's what would have happened. I'm certainly not advocating for anyone being beheaded here today, but the importance of the principle remains. And then the last thing that I think is important is I can all but guarantee you, your honors, if the trial court is upheld and we're forced to go to tribal court, they're going to take this opinion and they're going to say, hey, the Michigan Court of Appeals says we have sovereign immunity. You have to dismiss this. Now, is that binding on the tribal court? No, but I practice in the Sioux Tribe Tribal Court, and I'll tell you that they use federal and Michigan case law as persuasive authority. And that's exactly what I believe they're banking on. So, sorry, I will now get into the forum selection clause.
Right. I mean, assuming you're right about the sovereign immunity question, this case necessarily turns on the forum selection clause, right?
Absolutely. Which I'm going to go out of order on that because let's think about this logically. If we're right on the sovereign immunity, how did the judge ever get to the forum selection clause? Because it has no subject matter jurisdiction. It cannot make a decision on the forum selection clause. And just so that your honors understand how this happened is if the transcript is pretty clear. The transcript from the original hearing was he dismissed the case on sovereign immunity alone, not forum selection. Quaden filed a motion for reconsideration. The judge asked both parties to submit proposed orders. Judge went with their proposed order. That's what added the forum selection clause. But
just to be clear about that, it seems to me that the forum selection clause is central now if you're right on sovereign immunity. I mean, that is the be all and end all. That determines where you go. And they took it one step further. I mean, they got dismissal with prejudice, which means the case is over, even if you're right on sovereign immunity.
Right. Exactly, Judge. And so, yes, I don't want my first comment to mean that we don't want this court to rule on the forum selection clause, because otherwise we're back here in a year and a half or 2 years, right, on that same issue. So we would like a ruling on that. And of course, it's our position that there is no applicable forum selection clause. I want to make sure the timeline is very tight here. 2020, defendants were hired by the tribe only. Butts Along, actually through a different attorney at the time, represented the tribe in the underlying malpractice suit, the first one that came up. Defendants sent a letter to the tribe in Quaden saying, we are better to handle this. Quaden said, okay, go ahead and represent us. Defendants began representing Quaden. No agreement, no signature. That happens all the time in our world. I have clients that I'm stupid enough I've got 2 matters going on and this urgent things come up and I don't have them sign a new fee agreement. But I'm representing them and then they pay me. If they don't pay me, I can sue them for maybe an implied hourly rate because they've been paying it, up for a few months.
So, but when the attorney when general counsel had been retained by the tribe, and then they also said, oh, and we think we should take this case, and then they end up taking it. You're saying that the general counsel agreement is not what governs that relationship?
Not applicable, and I'll explain why. But it's curious that they quoted in their brief the 2022 contract, and the reason I was going with
right, but the 2020 contract is the one that
operable contract,
operable one,
right?
But it does seem like right after that was signed, general counsel goes to the tribe and they say we should take on this case, and then they do take on this case. You're saying that's just a random happenstance and it's not related to the general counsel agreement that had just been signed?
Absolutely. And here's why. Because the tribal governance, for example, requires the separate boards to make separate decisions. Now, absolutely, we admit that they're made of the same members, but what's the difference between 2 corporations with the same owner and manager, right? They're still legally distinct. The tribal code makes them legally distinct. Michigan law recognizes, the Supreme Court recognizes gaming entities as legal, distinct, separate entities. In that general counsel contract, especially 2021, the 2021 does not even reference the gaming authority or anything else. It states only, well, I won't even read it. But it does not reference it at all. The 2022 contract does reference not only the gaming authority, but the Section 17 corporation that's called STI, completely separate legal entity that the tribe cannot bind to any general counsel agreement. The 2020 doesn't even contemplate Quaden. So how, as a separate legal entity, can they be bound by the same terms as the tribe when there's 2 boards? If a tribal issue comes up if a Quaden issue comes up in a tribal board meeting, They cannot act on it, even if it's urgent, until they close the tribal board meeting and open the management board meeting. That is the procedure of the tribe.
As a practical matter, I'm baffled by your position on this. It seems to me that you would want to be in tribal court, assuming that the dismissal with prejudice goes away. We say it's without prejudice and off you go to tribal court. So you're saying you'd prefer to be in the circuit court than in the tribal court. Why? That makes no sense.
Sure, Judge. So this, regardless of what anything is going to be argued to the contrary, Michigan law will govern this. That's number one. Okay. Tribal courts, there is not a record of the Sault Ste. Marie Tribal Court being able to handle a complex malpractice case that ended up in an almost $100 million default judgment. Okay, so that's number one. Number two, domestication of a state judgment in Colorado, as our research indicates, is easier than the attempt to domesticate a tribal court judgment in Colorado.
I get it.
Yeah, and so
So as strange as it may be, this entity that is directly affiliated with the tribe would rather be in the circuit court than in the tribal court.
that's correct. That's correct.
So why does the 2022 agreement have a forum selection clause that you agree, if it had been operative, would apply to this case?
Well, I don't believe that the 2022 would be operative to this case either, again, because of what I just said about the two separate boards.
I got it, but.
But why would the
but you
tribe
said
agree to
Brett,
it?
you said it was accounted for in the 2022 agreement.
It was accounted for in the 2022
Why
agreement.
put it in there?
Well, that was defendants that put it in there, and then, of course, the tribe that signed off on their portion of it.
I got it. Right. But I mean, look, it doesn't matter who put a clause or a provision in play. The bottom line is both parties signed off on it.
Well, the tribe signed off on, again, these are
Okay,
different.
I understand.
Sorry, Judge.
It's.
I understand what you're saying. So I think that but it is important though that we have two distinct legal entities. And to go back to my example of my clients, if I have two matters with a client and an emergent one comes up in the third one, and I don't sign a fee agreement, then I might have relief options, but I don't get to enforce the same terms of those other contracts on my client's other corporation just because we have a relationship together. That's not how the law works.
So in other words, this is no different than if they had the law firm had a lawn care service on the side. You entered into a contract where they'd come and cut the grass at the casino.
It's fair. That's fair.
I mean, it's a more extreme example,
Right.
but that's essentially what you're saying. This is a completely separate piece of business doing something completely separate. And therefore, whatever our overarching contract says, it has no application because of the factual context in which this dispute arises.
Yes, and to your earlier point, Judge Yates, we still have if defendants are owed fees from representation in the Kuwaitan matter, they can sue for those fees, but they can't sue under a contract that's not signed by the entity they're trying to sue for.
Can I ask you a little bit more about this relationship between the two entities? In the complaint, the plaintiff describes itself as a wholly owned entity of the tribe. And then, of course, in the tribal code, the plaintiff's an instrumentality of the tribe. It's a subordinate organization of the tribe or the board of directors of the tribe. It's a subordinate arm of the tribe. I mean, why can't the tribe enter into a general contract agreement where the terms of that agreement, when your client is represented by the council in that agreement, is not, why aren't they bound by that
For example,
that representation?
yes, Judge. So for example, Kuwaitan cannot do anything without a signed resolution in accordance with the tribal code. In order to be able to sign off on this general council agreement, Kuwaitan would have had to make its own separate resolution to do so. It had to make its resolutions to be able to enter into the compact and the underlying malpractice. It wasn't the tribe that entered those, it was Kuwaitan. It also wasn't the tribe that was sued in the underlying malpractice case, it was Kuwaitan. Kuwaitan then sued in malpractice, not the tribe. But there are different governing structures required not only just by the tribal code, but also by the United States government in certain aspects of the Indian Gaming Regulatory Act, IGRA. So There are procedures that must be followed for each company, for each organization, the same way two Michigan companies have to follow certain procedures to not pierce the corporate veil. So the last issue I just wanted to discuss briefly was the with or without prejudice. We already talked about the fact that once subject matter's jurisdiction was decided, you can't decide anything else. But how can you say that you've decided the merits of the case when you haven't heard the case? I don't think I need to belabor this. The only thing I want to point out.
This doesn't seem like a hard issue.
Yeah, the only thing I want to point out is that we'd have the exact same thing I said otherwise. If you get a with prejudice, they're going to go to tribal court and go, hey, with prejudice, you can't hear this case either.
Sure, right. Oh, yeah, absolutely. It's preclusive. And that can't be right.
If there's nothing else, I'll save the rest of the time for rebuttal.
Oh, thank you.
Thank you.
Still, yes, it is still. Good morning, Your Honors.
A few minutes left.
My name is Eric Liebman. I've been admitted to your court pro hoc vice.
Welcome.
I work, I'm a partner at firm in Colorado. I want to thank the court for admitting me, and I'm very pleased to be here to argue this case. May it please the court, counsel. I think one of the key things that hasn't been mentioned and goes to some of the questions that the court asked, and also is necessary to lend context to some of the more high-minded, the king chopping off heads, the theoretical. And this is in the record, and this is exemplified by numerous of the cases that we've cited. And first, I'm going to say it's going to be hard to talk about sovereign immunity and the forum selection clause as completely separate things. And I'll explain why in a moment. But almost every, well, since Indian gaming became a thing, I believe in the 1970s or the 1980s, and has been utilized by the formerly impoverished Indian tribes to make contracts all over the country. There's probably more Indian casinos there than there are in Las Vegas and Atlantic City put together, and God bless them. However, virtually every one of these tribes, in order to effectuate their desire to participate in gaming, as it has been allowed by the act of Congress, every one of these tribes has set up a separate entity. And they set up a separate entity, and it's usually not a corporate entity. It's an entity, and I want to get away from the corporate because we're not talking about alter ego here. We're talking about a tribe that it's of its own volition said, we're going to create this separate arm. And maybe Your Honor, Judge Yates sees where I'm going with this, but you want to build an $80 million casino and you want to sign a contract with somebody, but you also don't want to waive your sovereign immunity, because sovereign immunity is very, very important to the tribes. Very. And I didn't even know how important it was till I started doing this work. They set up a separate entity that can waive sovereign immunity without waiving the tribe's sovereign immunity, which addresses the two things that I just talked about. Nobody's going to do business with them. They're not going to be able to hire contractors and people and counterparties and everything necessary if those parties don't have any recourse against them, which is exactly why, as Mr. Barnett correctly pointed out, in the contracts, the underlying contracts in this case, Kuwait waived its sovereign immunity. But because of the terms of the Chapter 94 of the Sault Ste. Marie Code, which sets up the gaming authority, that sovereign immunity does not waive the sovereign immunity of the tribe. And I think your honors know there are, I think, 12 federal, maybe 8 federally recognized Indian tribes in Michigan. That waivers aren't implied and waivers aren't given away easily. And a tribe is entitled, without opening the door, to set up an entity that can do business. And just,
I guess I'm not following a certain part of where this is going, because at the end of the day, if this malpractice lawsuit is successful, doesn't your firm or perhaps an insurance carrier have to pay? And that means the tribe is not the party in interest. And so I just don't see how you can claim sovereign immunity in this situation. You might in others where you're being sued as an agent of the tribe, but here you're not going to look to the tribe to pay the judgment against Kuwait if they prevail.
and
I don't know if I'm being clear in what I'm asking, but
I think so. And I think that there is a provision in Chapter 94 which sets up it's 94 of the Tribal Code. It's Exhibit F. I don't have the record site, but
I share Judge Karabkin's concern. This seems like a complete perversion of sovereign immunity of a tribe.
and I'm going to explain to you, Judge, why it's not. And this is where I think we're right at the intersection now of sovereign immunity and the forum selection clause and the law firm issue and the underlying issue. It is the tribe that will have to pay. The tribe does not have a separate economic existence. Kuwait does not have a separate economic existence except for the sole purpose of serving the tribe, and that's 94 what?
Just to clarify my question, if not the underlying state court judgment for millions of dollars or whatever, I'm talking about the malpractice lawsuit that's at issue here. Assume that your client firm loses that malpractice case. Don't they, they're on the hook for the malpractice judgment, not the tribe.
There is no economic difference between the tribe and Kuwait.
No, I'm not asking about that.
Okay.
And I'm probably not being very clear, but.
Or I'm not hearing clear.
Well, to me, it comes down to a question of who is the real party in interest being sued in this malpractice claim. It's the law firm. The law firm is being accused of committing malpractice. And so I don't see how the law firm, which is accused of being committing malpractice, can say we're actually the tribe and we have sovereign immunity.
Okay. And that's what I think has been a source of confusion, this notion, which I think is borrowed from collateral estoppel, defensive and offensive, and the king chopping off heads. I think this is where we switch over to the forum selection clause. The reason sovereign immunity and the forum selection clause can be applied fairly is that the tribe has waived its sovereign immunity in the forum selection clause. This is not a one-way street. This contract, we are an agent of the tribe. And if tribe's going to sue us for malpractice. There are the two common scenarios. The tribe sues us for malpractice. We sue them for our fees. The point of it is the forum selection clause says it's done in tribal court.
That's fine.
And that's the
But
key
there's
issue
a-
here.
There's a world of difference between resolving this case on sovereign immunity, which is therefore preclusive, versus resolving it under the forum selection clause, which at least I think, I can't speak for my colleagues, can't possibly be preclusive. It has to be without prejudice.
I think that it's with prejudice.
Are you telling me published opinions from this court are wrong? Where we say if we enforce a forum selection clause, it has to be dismissed without prejudice?
Because I think they're the same thing. If we were in federal court, the federal court could transfer. Here, in order to get over to the tribal court, it has to be dismissed without prejudice, and then dismissed with prejudice, and then it can be refiled in the tribal court.
Not if it's dismissed with prejudice. It can't be refiled anywhere.
If it's dismissed with prejudice, and it's
Are you saying that regardless of the terminology that's being used, are you saying that you're okay with this case being refiled in tribal court?
Absolutely, that's the entire purpose, and that's the intersection
Okay, so
between
then
sovereign
I don't know that
immunity.
we have to quibble about the terminology of with or without prejudice. Your position is that this case can be refiled in tribal court.
Absolutely.
Okay, all right. So now I think we need to talk about the forum selection clause and whether it really needs to go to tribal court or not. I mean, as I understand your opponent's argument, it's that we are Kuwaitan, we are not the tribe, and so that we're not bound by what the tribe says agrees to in its general council, 2020 general council contract.
And after an examination, we don't concede that the 2020 general council contract is the operative contract as opposed to 2022. It may be that it's a continuation, it's a renewal, it's a clarification, but at the time the first let me talk about the chronology, because Mr. Barnett brought up the chronology, and I think that's very important. But there's a date that wasn't included in there. So the Butts Along firm we'll go back to 2020, the early 2020. The Butts Along firm is representing Kuwait in connection with the underlying lawsuit. On June 3rd, if you look at the 2020 general council contract, there is a provision in this that says that by being the general counsel, part of what the general counsel, which is a term of art and an important thing, and to talk more about the general counsel contracts, it's a very common construct in Indian tribes. You hire general counsel, and then you can assign general counsel to handle an underlying litigation. The general counsel can hire another firm. They do all of this at the pleasure of the tribe. So when the 2020 general counsel contract was executed by the tribe and by the Patterson firm, the Patterson firm was not yet representing Kuwaitan. And so there was no Kuwaitan to put in here. June 3rd, the J states, June 3rd, 2020, Patterson is hired by Sault Ste. Marie. June 9th, 2020, the Patterson tribe, which is a tribe that's very, very well versed in Indian law and
Wait, you said the Patterson tribe?
Excuse me, the Patterson firm, Your Honor.
Thank you. Yes. Just like Mr. Barnett, the little boy on me is coming out. and
That would give more weight to the sovereign immunity argument.
Maybe they should have formed a tribal entity.
It is one of the only Native American majority-owned tribes in the country. But has more to do with their relationships with the tribes. It doesn't have anything to do with anything here. On June 9th, 2020, as general counsel, the Patterson firm tells the tribe, you are not being well represented by Butts Along. They should have done this. They should have done this as your general counsel. One of our responsibilities is to give you advice on legal matters and to assert any valid claims through appropriate legal proceedings. That couldn't say gaming authority then. It couldn't say Kuwaitan, because at the time this was executed, the Patterson firm was not representing Kuwaitan, and it was not representing the tribe as its general counsel. June 9th, the Patterson firm tells the tribe, you should use us. Maybe that certainly raises some bad blood, and how tactfully that was done has been the subject of discussion, but be that as it may, the tribe agreed. And the tribe said, okay, Patterson firm, you've done this over and over and over. You've persuaded us. You're experts in sovereign immunity. We are going to hire the Patterson firm to represent us in the Kuwaitan case.
To represent Kuwait.
To represent Kuwaitan in the underlying, the case within the case.
Yes.
To represent Kuwaitan as where Kuwaitan's a defendant.
So at that point, is the Patterson firm now general counsel for the tribe and litigation counsel for Kuwaitan or Kuwaitan?
On June 3rd.
Right, when that happens.
When that happened, the Patterson firm just became the general counsel.
For the tribe.
For the tribe.
And it became litigation counsel for Kuwait.
Subsequently.
Okay, but.
Yes.
Right.
Yes.
But in other words, it's not just wearing two hats, it has two clients.
No, Your Honor, I would disagree with that. They are not, it's an instrumentality of the tribe. It's, for example, frequently, I'll use Colorado. I think it applies in the federal system, but when agencies in Colorado, and I believe it will also when the EPA, some of the special agencies may have their own counsel, but frequently those cases are prosecuted by the Department of Justice. Here we have Kuwaitan. Kuwaitan is not a separate entity. And that comes out of every fiber of Chapter 94.
Right, but are there two separate contractual agreements?
No. The governing contractual agreement is the general counsel contract.
Right, but I thought you just said that first the Patterson firm became general counsel for the tribe. And then later on, not at that moment, later on, it became litigation counsel for Kuwait.
Correct.
And what you're telling me is there were not two separate contractual retainer style agreements. There was just one agreement. And for some reason, later on, without any paperwork or anything, the Patterson firm took over the Kuwaitan litigation.
And the paperwork, Your Honor,
yes,
is the general counsel agreement.
Okay. I just wanted to make sure I understood your position.
Well, I'm sorry, go ahead.
No, go ahead.
Well, so the general counsel contract provides that the firm is going to provide legal services as directed by the tribe. So
correct.
I understand what you're saying to be that pursuant to that agreement, the tribe, having had this nice conversation with Patterson, directed Patterson to take over litigation in that underlying case.
Exactly so, Your Honor. And because it doesn't say gaming authority in 2020 because Patterson wasn't representing the gaming authority.
So
However,
at that point, it seems to me the relationship, the litigation, the Quaden litigation is operating under the umbrella of the 2020 General Counsel agreement. But your opponent, of course, is saying, well, that was never an agreement that Quaden signed. That was just an agreement that the tribe signed.
but there isn't any difference. And one of the reasons Your Honor can tell that is in 2022, at the end of 2022, when the second General Counsel agreement was signed. And now this is after all the conduct underlying the Quaden Patterson lawsuit has been going on. The tribe re-ups with Patterson, briefly albeit, and they are about so long to sue Patterson. But at this point in time, 2022, the tribe and Quaden were still represented by the Patterson firm. And in the 2022 contract, it specifically says the firm's fees for all work outside the scope of the certain General Counsel services, including but not limited to work performed for the tribe's gaming authority, casinos, and other gaming operations. That wasn't relevant before Patterson was hired as General Counsel. Patterson didn't know there were other litigations going on. Patterson didn't know it was going to be right, nor did the tribe know that Patterson was going to be representing the tribe and Quaden. But given 2 years of litigation with the Patterson firm, they certainly knew. And the 2022 General Counsel contract, which was in place when this lawsuit was filed, Patterson hadn't been fired. Patterson was the attorney for the tribe. And if you look at paragraph 5, this explains and it elucidates the 2020 contract. They're very, very similar. Except this says, okay, now we know you're doing the Quaden case, and so we want to put more flesh to the bone. Here's the hourly rate, here are the terms, the billing, the language you would expect to see, and it also has the General Counsel language. We can assign and do this. But for example, the billing rates may be adjusted from time to time. The time will be charged for this and this and this. It's specifically, if you read paragraph 5, that is the tribe, or that is Patterson's contract with Quaden.
All right.
That's the fee agreement with Quaden. It's with the tribe.
Does a representative of Quaden sign off on that General Counsel agreement? Or only the tribe signs off?
The tribe signed off on it. The Quaden serves at the pleasure pursuant to section 94 of the tribe.
So just to be clear about this, and this is maybe where I'm struggling and I shouldn't be. In corporate law, one of the standard operating principles is that courts are to respect the separateness of corporate entities. So even if it's a parent and a subsidiary, they're treated as separate entities. You seem to be saying that in the tribal context, it's exactly the opposite. That not only are they not presumptively separate, they are presumptively one and the same.
They are presumptively one and the same. It's created for the sole purpose of the tribe being able to engage in the casino business.
So in other words, there was no reason for Quaden to sign the agreement because it was, in essence, a portion of or an alter ego of the tribe itself.
I'm going to have to quibble with alter ego because that takes
right, but whatever you want to call it.
Yes.
Right. That's why I tried to describe it broadly.
An instrumentality.
Okay, that's fine.
And if the court looks at the Gaming Corp versus Dorsey and Whitney case,
right,
that also refers to an instrumentality.
Right, I get it.
I mean, if the Department of Justice outsourced its work and asked for a law firm to represent the EPA, and the law firm agreed to do that, and then later on there was a dispute between the EPA and the law firm, and the EPA says, we don't have anything to do with that contract that DOJ signed. We weren't involved. I mean, that would be kind of an analogous situation.
Maybe I shouldn't have delved into that area because I don't have the expertise to say that. But assuming for the moment that the umbrella organization was the Department of Justice and the EPA was part and parcel of that.
Add the Marshal Service instead of the EPA, which
Okay,
is actually
the Marshal
which is a
Service.
component of the Department of Justice.
It's going to flow back up to justice. Just like here, Kuwaitan flows to the tribe. Kuwaitan has no purpose except for.
So it would have made no sense for them to be, for there to be a separate retainer agreement for the litigation if it was done, in essence, at the behest of the tribe, even though Kuwaitan was the one who was named.
And yes, Your Honor. And in 94.105, section 94.105 of the Tribal Code says subsection 2, for purposes of taxation, civil jurisdiction, regulatory jurisdiction, the authority shall be a subordinate arm of the tribe and shall be entitled to all of its privileges and immunities. Further, it goes on to say that to be on the board of directors of Kuwaitan, you have to be on the board of directors of the tribe. If you're on the board of directors of the tribe and you're not, then your term's up, you're kicked off, you're no longer a member of Kuwaitan. It goes on to say all the things that Kuwaitan has the power to do, but then at the same time, Kuwaitan has to report regularly to the board of the tribe, to make sure that what they're doing is okay.
Right. Getting back to what we're actually trying to decide that came out of the trial court here. I think what you said in response to a question from Judge Karobkin is you don't care if we say that the forum selection clause applies, but insofar as the circuit court can't hear it because of the forum selection clause, dismissal is without prejudice. You have no objection to that.
I have no objection to it being without prejudice if that doesn't preclude us then. Then I think, that without prejudice brings up the question of whether it's a final judgment.
Correct, right. Whether the litigation can continue in the selected forum.
So whatever mechanism you use, it can continue in the selected forum, and res judicata would be inapplicable.
Okay, so they would just have to refile, I guess, in the appropriate forum.
That's exactly right.
And that's it. But you have no qualms whatsoever about this case being decided by the merits in the tribal court.
Absolutely. That's the entire reason the forum selection clause is in there. And that's the entire reason there's no defensive, offensive.
Right.
Patterson using this against the king, because the tribe has said in both of these contracts that if we get into a dispute with you, Patterson firm, we're waiving our sovereign immunity, and any dispute between the two of us just narrowed to this contract will be resolved in the tribal court.
Okay, that's fine.
And that's all it is. The state court doesn't have jurisdiction because of the strong underpinnings of tribal sovereign immunity. And so what the tribe wanted and what the tribe has expressed by its language here.
I was with you until you said that last sentence.
I should have shut up.
No, I mean, I don't understand.
Speaking of which, Mr. Lieben, we only have about 1.5 minutes left on your time. So I think if you had something final you wanted to say, and I didn't mean to cut you off,
No,
Judge
no,
Yates,
no,
if you
it's
had another
fine.
question, but we're running out of time.
Judge Yates, I take it back. whatever it was.
No.
But But what I'm saying is because of the, okay, maybe this is where I erred. Because of the forum selection clause, in conjunction with the waiver of with Kuwait, the tribe's waiver of sovereign immunity, the tribe has expressed in these contracts, Patterson, if we have a dispute with you, it can go forward and there's no res judicata because the state court, tribal court issue in the forum selection clause. And however we get there, what the tribe has said was, we want to be in tribal court. Anything that happens between us and you, anything that had happened in those construction contracts below, the tribe is entitled to select tribal court. The tribe has a fulsome, your honors probably know this, as a fulsome tribal court and code of civil procedure and all the mechanisms available in order to resolve those disputes. And the government has said it can do that, and it's done that through the forum selection clause. Thank you very much, your honors. Thank you, counsel.
Thank you, Mr. Liebman, and thank you for appearing here today.
Thank you for having me.
Mr. Burnett?
Thank you again, your honors. The first thing I want to touch on, we briefed very thoroughly in both our motion, response to their motion to dismiss and this appellate brief, the issue that the tribe and Kuwait are one. And not, they're not one, they're two separate legal entities. That was our argument. Not once was that countered until this oral argument today.
So just to be clear, the corporate law analogy does apply in your view. There is separateness. We have to respect the separateness.
Not only in my view, but in the Supreme Court's view, and I'm going to say this wrong, but Kiowa, the Supreme Court in Kiowa, and also the tribal code, right? So if we are trying to allow tribes to self-govern, then we must look at their laws. And according to their laws, Kuwait is a separate legal, it says right in the tribal code is a separate legal entity. So
And
then
if you're right about that, of course, the general council agreement can't possibly apply to Kuwait. Not a
Possibly.
signatory, even if it's contemplated, it might be a third-party beneficiary at most, but nothing more than that.
yeah, and it wasn't even contemplated in the 2020 agreement, and
Right.
council just admitted that.
Right.
Right, and admissions of council are admissions of parties. And so, but then there's an argument of this adaptation to the 2022 contract, but listen to the words of the 2022 contract as it applies to the waiver. Because council also admitted, if I heard correctly, that the tribe cannot waive Kuwaitan sovereign immunity, and that's correct. The tribal board cannot do that. The management board is the only entity that can waive Kuwaitan's sovereign immunity. How could the tribe hire a law firm for a Kuwaitan when they can't even waive its sovereign immunity? And again, if you look at the tribal code, it can't enter into contracts for Kuwaitan. The tribe cannot enter into contracts for the Kuwaitan. The management board must do that. I understand they're the same people. But again, if I have two companies owned by the same person, you cannot bind one company just
Sure,
because
parent
the owner.
subsidiary.
Absolutely, Judge. But listen to the language of the 2022 contract with all of that in the background. Upon demand of any party, any dispute rising under or in connection with this contract shall be resolved in the tribal courts of the Sault Ste. Marie Tribe of Chippewa Indians in accordance with the laws of the Sault Ste. Marie Tribe of Chippewa Indians. The Board of Directors. Defendants know exactly who the Board of Directors are. The management board is Kuwaitan. The Board of Directors is the tribal government.
That's a term of art.
It's a term of art. And again, in the tribal code that we are supposed to take as law. The Board of the Directors agrees to waive the sovereign immunity of the tribe. It doesn't say the Board of Directors agree to waive the tribe and the management board agrees to waive Kuwaitan. No, it doesn't say that. So to try to impute the 2022 contract, I don't think that that's acceptable. And I just want to correct, the tribe didn't agree to allow defendants to represent Kuwaitan. Kuwaitan agreed to it. Defendants entered an appearance on behalf of Kuwaitan, not the tribe. The lawsuit was against Kuwaitan, not the tribe.
So part of the 2020 general contract agreement that says sorry, it says that that the law firm is going to undertake, it's going to undertake, it'll provide legal services as directed by the tribe. So you're saying that's not what happened here. The tribe didn't direct Patterson to provide the legal services?
That's absolutely correct, nor can it. It cannot direct Kuwaitan to hire counsel. Kuwaitan must hire counsel. I have two separate agreements. I have an agreement with Kuwaitan. I have an agreement with the tribe proper. And I want you to consider, you know, that 2022 agreement, the Section 17 Corporation, STI. There is only one board member on the tribal board that sits on the STI board, and they don't even have voting rights for most. It's pursuant to a charter, right? And that's a separate legal entity under the law. The tribal board cannot hire for them, cannot bind them to anything. Only the STI board can do that. And there's a tribal member on there as well.
So looking at the 2022 General Counsel Agreement, which I understand is not the one that you say is applicable here, but it is the 2022. It says in paragraph 2, it says the firm is only going to act on the matters that are specifically directed to act by the board of directors. Okay, all right, and then on the next page, it says the firm's fees for all work outside of the scope of this general services listed in the prior paragraph, including but not limited to work performed for the tribe's gaming authority, and then it provides, you know, the hourly rates and stuff like that.
Yes, Judge.
Doesn't that suggest, at least in the 2022 contract, that the firm will be doing work under this contract for Kuwaitan?
Yes, but it's not signed by Kuwaitan. And you can't contract as a third party you can't bind a third party to a contract. The third party has to bind itself to that contract.
And so this agreement is just kind of void as to any work that's being done for Kuwaitan.
Yeah, and again, the defendants would still have any articulable unjust enrichment or maybe even an implied contract claim, but not under the terms of that agreement, under the terms of the customs and policies that the parties had done, right? So the hourly rate would be the only thing we have in the record that would be evidence at all.
So the chair of the management board would have had to sign the 2022 agreement?
Absolutely, as would the chair of the STI, the Section 17 Corporation. And I believe there's one other corporation there. Maybe it's the government, the healthcare. I'm not positive, but all of those would have had to sign because they're all separate legal entities. And the thing is it's not like this was a contractor that doesn't know the law. This is a law firm that knows the unique structure. They know this. They just didn't anticipate this type of a problem, is what I would assume. If there's nothing else, that's all I have, Your Honors.
We're often here because someone didn't anticipate.
Never.
Gets us into the courtroom.
Never. That never happens.
That's fair.
I don't have any other questions. Yeah, thank you very much.
Thank you very much for your time.
That case will be submitted. And at this point, we've been going on for a little while. We're going to take a quick break before we come back and call the remaining cases. Okay?
Right. Court of Appeals State Bench is now in session.
Okay, we are back. Thank you for your patience. Resuming our case call, we're gonna call item number 6, docket number 371706, Frage versus Frage, and I apologize if I mispronounced.
Exactly right.
Okay.
Bravo.
Good to know.
He's been practicing.
I was battling with that the whole time. We should require people to put like, you know, phonetic spellings, because as I'm reading things, I'm like, how does this, what is this?
We had to put him on Supreme Court cases too.
I agree. Yeah.
So we'll start with the appellant, and Ms. Schmidt, I do see you on camera there. So if you can hear us, you're free to get started whenever you're ready.
I can hear you, Your Honor. Can you hear me?
We can. Thank you.
Great. And I would like to just take a minute to say I've been looking forward to a chance to argue in front of you, Judge Korobkin, for quite a while. So I'm glad to have the opportunity.
He's feisty today. You better be ready.
Oh, he's been feisty for years. when reaching a fair and equitable property division in a divorce action, what is good for the goose must necessarily be good for the gander. The trial court here applied different standards and different division dates to accounts for the husband's name than accounts with the wife's name. This resulted in the husband's premarital property being divided, while the wife's post-separation income was given to her as separate property.
Didn't they combine the premarital? I mean, I told people for 22 years that once you make an omelet, I can't recreate the eggs.
Not in regard to the PWC accounts, Your Honor.
I agree with respect to that. I agree with respect to that, that I think that the judge should have recognized the premarital version. Can you tell me, I mean, Judge Alexander is really a judge who's usually on top of these sorts of things. Was the presentation of evidence, in your perspective, just, I mean, I would have usually had these things laid out. Okay, here's the premarital, here's the marital, and those sorts of things. Or was it just that because of the parties' positions that all of this is premarital, that the judge kind of just went, oh, okay, this.
I think there was a little bit of both, Your Honor. I did review some of the exhibits this morning in preparation. There were a significant number of stipulated exhibits, including statements regarding the stock trade account, including transaction histories, et cetera, et cetera. That was all in front of the court, but the actual testimony was often significantly muddled, especially like when things happened. The parties would disagree whether husband received a gift from his father in 2015 or 2018. There was a lot of date issues in the case. So I think that there was a little bit of both. There was maybe a bit of overreach by trial counsel saying, oh, well, if any part of this is premarital, all of it is premarital. We know that's not the case. But also maybe some of the fine distinctions didn't get into testimony because they were already admitted in the exhibits. Before we get too far into the case, Your Honors, I did want to acknowledge that I believe the judge reassignment portion of my brief may be moot. Is my understanding from speaking to my client yesterday that Judge Alexander has not been hearing the post-judgment issues, and the case was transferred from Judge McDonald's docket to Judge Dare. So as long as Judge Dare is the judge hearing the case on remand, I don't see a need to do a reassignment because it would remove the issue that we had raised in our brief. So I did just want to very briefly address that before we got too far into what Judge Alexander did and didn't do. But did I answer your question, Judge Feeney?
You did.
Okay, great. Just to finish my introduction, I think we also want to acknowledge the fact that Judge Alexander's ruling on the attorney fees was summation, I'm saying that word wrong and I'm going to just reword it. It was a one-liner decision about the amount, and then he doubled it without any explanation beyond the disparity between the parties.
Mr. Schmidt, let me just make sure I understand what you're saying. It sounds
Sure.
you're saying because there was no finding made along the lines of Pergu, that in and of itself is reversible error. You can't just say $40,000 and that's the end of the story. There has to be the three-part buildup where you have to get the hourly rate and then the number of hours and then make adjustments on the 8 non-exclusive factors. Are you saying that's the one and only defect with the $40,000? Or are you saying there are lots of problems with it, but that's one of the problems, so just send it back and let's get some detailed findings on it?
The latter, Your Honor. First of all, there was no indication whether this was an award. I mean, disparity suggests it was under subsection D2A rather than D2B, but there had been allegations of both.
Yeah, hold up a second. So I think what you're saying is there might have been an argument for need, there might have been an argument for fault, but we can't even tell whether this was based on need or fault or some combination of the two?
Correct. And then we also don't know how he reached that number because he reached a different number not 5 pages earlier in the transcript.
Okay, thank you.
But Ms. Schmidt,
Yes.
would you agree with me, though, that divorce cases oftentimes in these circumstances, trial judges tend to try to equalize attorney's fees without going through the entire Smith versus Corey and Pergu analysis?
I think that would be true if the judge had stopped with the attorney fees will be paid out of the joint marital account. or even saying the DFCU account, which was in his name only, but if there was the acknowledgement that it was marital because it was earned post-separation, if the judge just said, we're going to equalize those expenses out of the joint account or out of the bank account, I would agree with you. But here, Judge Alexander went further and said, and 40,000 of that is going to come out of husband's share of that account. So yes, I agree with you, Your Honor. A lot of times we are equalizing and we use shortcut language. I'm not concerned about that. I'm concerned about this specific carve out that the additional funds were paid from husband's share of the account.
Thank you.
So I do want to primarily focus on the separate property, although it sounds like Your Honors are interested in the attorney fees, so I'm happy to go into it further if need be. We talked slightly about the PNC or PWC accounts already. Your Honors, regardless of the how do we draw the line, the dates for the employment and the marriage were very clearly in the record. It would have been a very easy thing for the court to say the marital portion and would have solved the entire problem. And this is compounded by the fact that the court did award the wife all of her premarital, the Deloitte pension and the other accounts, the Morgan Stanley accounts, all of those were dealt with as separate property. But the biggest one, the one that had, by the time of the divorce, $792,000 in it, and at the time of the marriage, approximately $93,000 in it, that one, we're going to ignore the premarital share and we're just going to divide it all. So I think that is a factual issue. Go ahead.
Just a second and help me understand this, because there are a lot of accounts here. As I understand it, he set up his own separate account and he moved some marital funds into his separate account. Then she, either in retaliation or for self-protection or whatever, set up this Chase account of her own, right?
Okay, so as you said, Your Honor, there's a lot of accounts here. I will say in 2021, the parties became financially separated. And at that time, husband's income started getting transferred into the DFCU account. I believe he did also transfer funds into the DFCU account at that time. I don't think a specific amount was stated in the record, but I will concede that that transfer happened in 2021. And that after that, the wife was using her mother's account, and then eventually she creates her own account, and there's a question of when the mother's account comes out of the equation. We end up with DFCU account is husband's account where husband's income is going in and all of the household expenses are going out. And there is a Chase bank account, which trial counsel inartfully referenced as her separate account, that was for her money that she was earning through her employment. And that one was awarded entirely to her as separate property. And that is a different issue that I find to be
right. Stop right there, because that's what I wanted to ask you about. Because one of the complaints you have is the Chase account was all awarded to her, everything. But I think you make a pretty good argument that there were some marital funds in the Chase account as well. Help me understand what you mean by that, because I think you're probably right about that, but I don't understand it entirely.
So first, we have that there was, I believe, some funds that were transferred into that Chase account at the time that the parties separated, but also wife's post-financial separation income continued to be auto-deposited into that account. And we know...
I thought that the husband closed off her ability to go ahead and access the funds when he moved them into the DFCU. That's why she had to open the Chase. Am I incorrect on that?
I think the argument is that because he moved them into the funds into the DFCU account, which was in his name only, she could no longer access them. It's not that she couldn't access the joint account, but the funds were no longer in that account. So to that extent, you are correct, Your Honor.
But so did the joint account still exist after he created the DFCU account and then moved a bunch of stuff into there?
I think so, but I think it had a very small balance, Your Honor. At least at the time of trial, the balance was very small.
But he essentially, you know, said, okay, all of this is mine and you do what you're going to do. And she established that. So, I mean, his DFCU account was this big. Her Chase bank account was this little one, right?
I'm not sure how small that actually was. Let's see if I have that number readily available.
There were big differences as far as I can.
Yeah, I'm not going to argue he didn't make a lot of money. He did, and that account also had the payback of his principal interest in the PWC account that he received after he had been separated from the company. So yes, that DFCU account had a substantial balance at the time of the judgment. And I'm not trying to say he should have been awarded all of the DFCU account. I'm saying if we're going to treat that as marital because it had money in it that was accumulated after the financial separation but before the divorce, we got to do the same thing for hers. We've got to treat both of the parties the same if we're going to come to an equitable outcome.
But it seemed that the judge in his bench opinion made it very clear that he believed that the defendant was not obtaining new employment intentionally. I think the comment was, I think he gave his bench opinion like on a Thursday or Friday. He said, I assume he'll have a job by Monday.
That is accurate, Your Honor. And in fact, if my client got to form the issues, that would have been the main issue, because he believed, and the record does suggest that the judge had already made a determination about the voluntariness of his unemployment prior to trial.
No, there's no evidence of that. But I mean, everybody says, oh, well, they're biased against me. No, you sit as a trial judge and you listen to the evidence and you make findings and come to conclusions based upon the evidence. And I saw nothing in there that said that determination was made before the trial happened.
Okay, I'm not going to push that one because I think that the finding continues to be incorrect even after we have the expert testimony and the distinctions that were made by appellant in his testimony. Because the expert in this case testified that he had found all of these CPA jobs that the husband could do and he could get paid all of this money. And then husband comes on the stand and he says, yeah, but I'm not a CPA. I'm not certified to do the work that the expert wanted me to do. So do I think that there's a possibility that he was waiting out his non-compete agreement because he likes the kind of work he was doing before? It's entirely possible, but we do have significant testimony in the record that he was trying to find regional employment that would not conflict with the non-compete agreement. He had simply not been successful because of this circumstance where he was not certified to do a lot of what was expected of people in similar jobs to what he had. So I think the point I'm making is I think the judge's determination on that was erroneous, but it also doesn't directly reflect on the separate property issue. If anything, it reflects on the attorney fee issue. So the most complicated circumstance here is the Apple stock. This is where we have our factual issues where everybody disagrees on how that stock was purchased, and we have the expert trying to connect the dots and leaving a dotted line in the middle. I have to say that contributions of we have the potential that this money may or may not have come from from the marriage gifts. However, we don't have a transaction that puts that money into the account to buy the stocks. That means that the only thing that was there was husband's premarital money when the stocks were purchased. We know that in order to establish it, we need tracing. She could not trace it. Her expert could not trace it. And so
wait, hold on a second. So you're saying, I thought that there was a finding with respect to the fact that she had put in money in order to purchase you're talking about the Apple stock?
Yes.
Okay.
I agree that Judge Alexander found that occurred. I'm saying that finding was erroneous based on the expert's testimony that he could not find a deposit. He said it must have happened because the balance didn't line up otherwise, but he could not find that deposit.
But you agree with me, Ms. Smith, that when you have accounts like that have multiple people adding money into them, there's no way for you to say that, okay, husband contributed 97% of the payment for the Apple stock and the wife only contributed 3% of the Apple stock. Once you make the omelet again, you can't pull out the egg. And so the fact that there was contributions made by both of them is what's determinative.
I would agree with you, except that the premise is false, because the issue that we're debating on is the one and only time the wife made any contribution arguable contribution to the stock account. What I'm saying is that that contribution was never made by the wife. She never contributed to the account, and therefore it was a premarital account. All of the transactions were within that separate account, and it remained separate. Now, I'm going to anticipate Mr. Dresden's argument about, I'm sorry, Dresden, I said the wrong name, Mr. Drasnen's argument that, well, what about the taxes? And we know that under Reeves and Korth, in the case where there's some substantial contribution of a small amount, that the contribution award should be proportional to that contribution. So maybe she should be entitled to half of the taxes paid, but she shouldn't be entitled to half of the entire balance when she never made an actual contribution into the account.
But once you have a separate account and you add the other person's money in, it doesn't become a partially marital, mostly separate account. It becomes a marital account. So
I agree with you, but she didn't.
And if the judge found her to be more credible than your client, we can't go back and say, oh, well, okay, we're just going to ignore his determination on that.
You can, because factual findings are reviewed for clear error, and the expert specifically testified that he could not find that deposit.
But she said she deposited.
She said she deposited. He provided the documentation that showed that it didn't happen. He demonstrated that there was no wire transfer into the account in the days leading up to the transfer. And the expert could only say, well, I have to assume it's true because I can't make the books balance otherwise. And notably, the expert did not have data from prior to the transfer, only was given data at the time of the transfer, does not know how much was in that account before we started. So
that's something that should have been taken care of at trial.
Maybe, yeah. There's always mistakes made at trial. We could have definitely cleared that up, but I think the record reflects clear error in the court's determination that the wife deposited that money. It's simply not there in the paperwork. And so I think that that was erroneous to award the Apple stock to wife. And at the very...
But Ms. Schmidt, it's different when you say, she says she deposited it, and the expert says, well, I can't find it. That doesn't mean that the evidence is so greatly overwhelming in the opposite direction. The trial court had the ability to determine credibility of witnesses, and we give the trial court deference with respect to their determination.
But the husband also demonstrated that there was no wire transfer. It wasn't just wife said I did it, husband said she didn't. It's husband showed the transfers in and out of the account and said it didn't exist.
But the expert, and you just said he couldn't determine whether it was made because you only looked at the evidence on the date of the transfer, of the alleged transfer.
The expert did, correct. And then when appellant was brought up on direct, he testified that there was, or he testified that the records showed there was no wire transfer at that time. I'm sure that I'm going to have some rebuttal comments I'm going to want to make. I think we've kind of gone around on all of the relevant issues. I did also raise an argument regarding the marital home. I think that one's pretty clearly laid out in the brief. I'm not going to dwell on that one. If the court has any other questions, otherwise I'll reserve my time for rebuttal.
I think we're good. Thank you, Ms. Schmidt. Mr. Drasnen, I assume you're the arguer here?
I am, even though I believe Mr. Falk is present in the courtroom, and I would like to reserve a bit of my time for Mr. Falk should he have any comments when I'm finished.
Well, usually we just go with one of you. So,
okay.
Mr. Drasnen, you should try to do it all.
I will do my best, Your Honor. Thank you to the panel. I see the panel is well read and has had an opportunity to review the various briefs and submissions in this case. I was, in fact, trial counsel, so I have significant information at my disposal. I'm going to track backwards here from where Ms. Schmidt left off. We'll start with the Apple stock issue. The Apple stock issue, there was verifiable documentation provided by my client evidencing the acquisition of the stock. My client had lived in Connecticut and New York prior to the marriage. My client was able to produce receipts showing multiple transactions from, I believe it was from her Orange bank account, which she attempted to transfer into the Scott Trade account that Mr. Frage had at the time. They couldn't do the transfer, so I believe they had to reroute it through a Chase account. She transferred $100,000 which was the amount of the purchase for the Apple stock. And the timing of this was within a matter of days for when the acquisition of the stock was made. There was testimony that some of the money she transferred, the bulk of it was her separate property holdings. Mr. Frage never disputed that, nor was he able to rebut that. And there was some wedding gift money that was blended into that. Mr. Alfonsi was our expert. He testified that he reviewed the documentation, and I'll point out to the court, not all of the documentation was readily available because of the age of the transaction, but we utilized what was supplied. That information, as Mr. Alfonsi testified, showed that there absolutely was money that came in. He did a calculation to determine what amount of money could have been in the account at the time, which I believe Mr. Frage indicated was Ford Motor stock. And Mr. Alfonsi, by doing certain calculations and reviewing tax issues, determined that it was de minimis in value in the account. So it was an influx of new money that came in the account to buy the Apple stock. There was no clear error. And candidly, if there's an error in terms of producing other paperwork, that's on Mr. Frage. Judge Alexander clearly found Mr. Frage was not credible at multiple times during the course of these proceedings. And just to comment, there was a statement made by Ms. Schmidt that Judge Alexander, at least in terms of the employment issue, had prejudged this case. Judge Alexander didn't handle this case prior to the parties appearing and going to trial. That was a matter that was in front of Judge McDonald, and she ultimately assigned it to Judge Alexander for trial. Getting back on the Apple stock issue, clearly my client made the contribution that caused the acquisition of this stock. It was only when the divorce actually started that suddenly Mr. Frage claimed, oh, it's not a marital account and you're not entitled to any of it. In terms of the joint funding, let's talk about the DFCU account. Mr. Frage was holding approximately $1 million in the DFCU accounts, and this is all marital money. None of it's premarital money. It is correct. There was a joint DFCU account, actually two components of the account that Mr. Frage allowed Mrs. Frage to have access to. The total in those two accounts was a whopping $3. So Mr. Frage is sitting here with almost $1 million, and he left his wife access to $3. In 2021, Mr. Frage was on my client to go out and secure employment. So she was able to secure employment with the University of Michigan. And then he got upset when he figured he would have to pay for childcare expenses. So he was upset that it would cost him more money than ultimately she may earn. They had a financial separation of sorts where, in essence, he got very angry with her and tried to lock her out and purposely didn't put her on these financial accounts. Prior to that point in time, she had been managing the household finances, taking care of tax work, and doing what was necessary. He cut her out.
So then she, whether as a matter of survival or retaliation or whatever
Yes.
it may be, she opens her own Chase account,
What
right?
she did, she got the job at the University of Michigan. She, on an interim basis, utilized a financial account with her mother in order to be able to pay some bills for a period of time before she would have an influx of funds coming from her University of Michigan employment that she could then take over and pay her own bills. That's all that happened. And I know.
So as far as the Chase account goes, she winds up getting awarded 100 cents on the dollar, right? She gets that account herself. They argue that it was commingled with some marital funds. What's your response to that?
The only response after that is the totality of the funds in the Chase account were by virtue of her employment. And to be blunt, the Chase account had $2,000 in it. Far cry from the $1 million Mr. Frage had in the DFCU account. $2,000 because she was paying regular bills out of it. She was paying for maintenance for the children. She was paying for food for the household and any number of other expenses. So she was working, paying credit card bills. $2,000 is all that was left in the account.
But did it have any marital assets going into that account?
No. No, the account was established after she got her job at the University of Michigan, and the funding of the account was from her payroll.
Completely.
From University of Michigan.
You want to talk about attorney fees because that's clear.
Absolutely. So
we know there's a gross award of $40,000, but beyond that, I mean, obviously there's no compliance with Purdue and its three-step analysis. I suspect you're going to say that doesn't matter because, as Judge Feeney was suggesting, it may have just been an equalization amount. you want to try to take that on?
I do, thank you. So early on in this case, I would say probably within about 5, 6 months after it was filed, we've presented a motion for payment of attorney fees because he was holding the family wealth. And the judge at that point in time ordered an equalization of fees and he had to write a check from their joint funds. That request was made again in advance of trial, and Judge McDonald said you'll deal with the trial judge on that. The attorney fees had become significant because Mr. Frage frustrated and was an obstacle to discovery in this case. He didn't timely answer interrogatories. I had to file a motion to compel. I then had to file a motion for more specific answers. I had to file a motion to secure records from PwC, which he objected to producing because he didn't want his wife and the rest of the world to find out why he had lost a job. It wasn't a voluntary relinquishment because he got tired of travel, as he claimed. It was for cause on the basis of the employer. They terminated him. So this issue came before the court. This judge oversaw 5 days of trial, and I know the court has had the opportunity to review the transcripts and observe that Mr. Frage was less than an ideal litigant in this case. The judge found him to be, he lacked credibility throughout the proceedings. So when we concluded, there's a transcript, there's a record. I provided certain information on the record so the court could make an educated determination on an award of fees. I offered the court a bill of particulars. Counsels both testified, and stipulated, I should say, as to the reasonableness of the hourly rates. So we didn't necessarily need to go through the entirety of the Pergo factors. We talked about each counsel addressed how much funds they were owed in attorney fees. I'll also point out to the court that in Cassidy versus Cassidy, that's 318 Mishap 463, 486 through 488. When a party does not challenge either the hourly rates or the work performed with regard to requests for attorney fees, there's no error if the court does not conduct a full evidentiary hearing if there's been a sufficient record created in order for the judge to review that record and make a determination on fees.
Is your understanding that the award was need-based, fault-based, or some combination of the two?
Combination, Your Honor, because the court made a determination that Mr. Frage had been earning upwards of $800,000 to $1 million a year before his employment terminated. The court also imputed a level of income to him at $200,000 during the course of this divorce trial. Ms. Frage was earning $67,000 at the time. And there's also a record, the judge originally signed the case had reserved the issue of attorney fees for Mr. Frage's discovery violations and noncompliance. And there was a whole history of that as we proceeded through the case. So what Judge Alexander did, because once again, Mr. Frage maintained all the assets, he ordered that each party's bill be paid. I think at that point in time, each party had a bill of around my bill, I think, was $85,000 through the day prior to the last day of trial. Opposing counsel had been paid significant dollars while I wasn't. I think they had been paid $70-some thousand through that point in time. So he directed that the balance of the bills be paid and that out of Mr. Frage's share of the property settlement, that $40,000 be paid to my office. Contained within the judgment is a schedule outlining how all the payments were to be divided up and paid out. But clearly, the court had ample cause and reason to impose this award against Mr. Frage for his conduct throughout these proceedings and his ability to earn an income, his level of income, and that's how the court modeled this particular award. And once again, Judge Alexander sat through 5 days of, trial testimony and was able to make his own determination why an award of fees was appropriate.
Was there any reference to not just the court rule 3.206, the D2A or B? I know they changed it, so I always go to C other than D.
Right.
And with respect to the discovery rules, isn't it 2.313?
Yes, yeah, there is reference in the transcripts to that, and there were also court orders entered that the issue of fees was reserved. I briefed this issue with a comprehensive trial brief. All those items were addressed in the trial brief, which the court reviewed. And certainly there was testimony on all these issues. The parties both testified. And as I indicated, I stood up before the court and provided sufficient factual and background information relative to my qualifications as counsel and how the fees were justified. And as I indicated, both counsels stipulated to the reasonableness of the hourly rates charged by counsels. And as I said, the court has had the opportunity to review the transcript, so there's a detailed and well-developed record in this matter.
Was that on day 5 that you folks did that?
I believe so. I believe it's, I think it was the latter part of the morning or early afternoon when right before Judge Alexander offered his opinion, and there were discussions interdispersed within the record relative to what had transpired in terms of attorney fees. Let's see, what else can I tell the court? The council raised an issue regarding the separate property nature of certain retirement accounts. Mr. Frage produced no documentation to identify any specific separate property funds. There is in the judgment of divorce a provision whereby each of them were allocated and awarded certain separate property retirement funds that they were able to establish were separate property funds. That's contained in the judgment of divorce. I think Mr. Frage got an account that was valued at approximately $115,000. So quite simply, Mr. Frage never produced documentation. He didn't produce any witnesses to support his claims of separate properties. He didn't produce any experts. He did nothing.
Was there any claims under MCL 552.401 and 552.23 with respect to Ms. Frage, accumulation, improvement, acquisition? And that's why if there were any separate property that it should be invaded, I don't remember.
Yes, there were, Your Honor. There was testimony and there were other proofs put in that she had been an integral part of this. In fact, I think Judge Alexander commented at one point in time that the parties utilize these financial accounts or other assets, quote unquote, as their piggy bank. So my client was a supportive spouse. She handled many different financial aspects of the marriage. She took care of Mr. Frage, the children, the house, and she was actively involved. So absolutely, my client contributed towards the accumulation or accrual and value of all of these assets.
But I didn't see in the transcript on the May 17th, 2024, where he cited to that. You know what I mean? Because that really, when a judge does that, it really undercuts the other side's ability to say this is separate property.
Well, I don't have that transcript at my fingertips, but I know Judge Alexander did his best under the circumstances to create a good record, to come up with a property settlement award that was equitable in nature, and to address the issues that were brought before him.
Well, if there's nothing else, we'll move to rebuttal. Thank you, Mr. Dresner.
Thank you.
Ms. Schmidt?
All right. I don't want to beat a dead horse, and I'm not going to go through it all again. The one thing I do want to say about the documentation provided by the wife is that all of those showed transfers between accounts in her own name. They never cross over into the investment account. I'm going to leave it at that. We've gone through the rest of it. I just wanted to make sure that the record was clear on that. As far as the fact that Judge Alexander was appointed to the case shortly before the trial, that's accurate. He had one pretrial conference, and it was at that pretrial conference where he made the statements that led to believe that he had already determined that my client was voluntarily unemployed. I'm going through these quick because there's a lot of little nitpicky stuff, and it's not especially important, but I never know what's the tipping point for you. As far as the idea that the husband had somehow whisked away all of the financial assets, this happened because, or in short proximity of, the wife obtaining employment. She's not penniless. She's making $60,000, and she's
Schmidt, when one spouse, because I mean, why do we sign the play nice orders at the very beginning? We entered the mutual restraining orders, which everybody hates, but in family law, they're our bread and butter, right? Because you can't empty the account, you can't move the account, you can't cancel the account, you can't cancel the insurance, you can't cancel the credit cards, because we want to get a snapshot of what's going on. And I don't know how you can argue with a straight face that, well, she got this $67,000 a year job and he wiped everything into his DCFU account, because that's just what people do.
Well, that happened in 2021. Well before the divorce. So I think that that was the point of the financial separation, but I think it's a little dishonest to say that the husband who is paying for all of the household expenses while she continues to live in the home isn't receiving any benefit just because she can't put her finger on the money.
But for her having her job, she did nothing. She did nothing. And she was paying the bills prior to that out of the marital funds. Great, he took it over. That's really nice. But I mean, leaving $3 in the account, really?
That was a big but for, Your Honor. And also the record demonstrates that part of the reason he had to take over the financial management was that they were running into problems. They were getting HOA letters because she was refusing to pay landscaping, et cetera, et cetera. So it's not just a matter of like, this is my money, you can't touch it anymore. There was some financial mismanagement going on at that time, and he wanted to clarify things. There is on the record, and I believe it's the wife's testimony, that demonstrates that the husband was paying 75% of his income to the household expenses post-financial separation, while the wife was only paying 39% of her income towards those expenses. So she was
the portion that if you put it into the child support formula, that's the way their income breaks down, right?
I don't remember the child support breakdown because that was not a matter at issue, so I did not closely review that.
But that's what people do all the time, right? They put it in the child support formula and he's got 75% or 73%, she's got 25%, and then they have them pay the bills according to that. So
I agree that's a normal course. I don't think that's what's happening here. I think that was a review of the transactions past tense rather than an estimation of how they were going to divide things once a child support order was entered. So I think we're seeing something that looks similar and assuming it's the same, but I don't think that's true. I do want to ask this court to be very careful when dealing with the issues protected by the confidentiality order. I believe brother counsel may have inadvertently crossed the line. We need to be very cautious about honoring that order because it is reflective of a contract of confidentiality that my client signed with his employer as part of the severance. That is why the discovery got held up, not because he was being obstinate, but because there were things he was legally not allowed to disclose without a court order. And he needed the protective order before he could do it. As far as the amount of the attorney fees, while it was not a fully litigated issue that was argued in the trial brief or in the closing arguments, my client did say on the record on May 17th that he objected to how much the attorney fees were costing and said that it was because the wife was delaying the proceedings. So the reasonableness of the number of hours was preserved in a very inartful way because it came through in the husband's testimony rather than the arguments. So the court should have done that Purgu analysis and did not. Just another tiny thing to keep in mind, although it does become relevant, that employment that we're talking about that changed everything, that happened, the end of the employment and in fact, the end of the payment of the severance happened before the start of the complaint. This is, the divorce happened because wife stopped getting the PWC money. Because that money was no longer coming in to pay the bills. That's why we're getting divorced. And so we want to be careful about saying that he did all these things wrong because he did, he did them wrong, it wasn't during the divorce. He wasn't receiving advice of counsel when he was making these choices. So I think we should be careful about thinking about when these things happened in comparison to the motives for divorce and so forth. The termination happened at the beginning of 2021. He was being paid through 2022. As soon as the money stopped coming in, she files for divorce. Judge Yates, I believe you asked, no, I'm sorry, this was Judge Feeney. You asked if the court referenced any of the court rules regarding attorney fees in making its decision. The answer is no. The court did not determine what basis it was awarding attorney fees under in any way, shape, or form, just set a number. Similarly, the court made no findings for invasion, referenced neither of the invasion statutes, made no determination that there was a contribution, just said it's a marital asset. So there's no reference to that issue as well. And my last point is that the piggyback reference is part of the error because it references the Apple stock account. I'm sorry. Yeah, it referenced the Apple stock account from which There were 2 withdrawals. I'm wrong. It did not reference the Apple stock account. It referenced the premarital separate financials that the husband had. There were 2 withdrawals when they bought their first home and when they bought their second home. That's not a piggy bank. That's making a conscious choice to put separate property assets into a major purchase. I'm done, Your Honors. I know that was a shotgun.
Okay, thank you both. That matter will be submitted, and appreciate you appearing here today.
Thank you, Your Honors.
Thank you.
Good to see you, Mr. Falk.
27 days ago, I was in front of Your Honor and wishing you well in your retirement, but.
And here I am again. You can't get rid of me.
So I again wish you well.
I'm around for a while. Thank you, Mr. Falk. Appreciate it. Not going anywhere today or tomorrow.
All right, have a good day. The next case that we'll call is item number 7, docket number 372749, In Re JES. Good afternoon.
Good afternoon, Your Honors. Rachel Helton, appearing on behalf of the respondent appellant JES. And I think that this set of facts is, compared to all the other cases I've sat through this morning, quite simple and straightforward. I understand that you've read the briefs. I'm not going to rehash what is in my brief, but just by way of summary, I would like to direct Your Honor's attention to MCR 3.922. That is the court rule involved in this case, and it states that opposing parties are entitled to the other side's all written and recorded statements and notes of statements made by the juvenile or respondent that are in possession or control of the petitioner or law enforcement agency.
I think you can probably stop that at this point, because it seems to me the trial court made the finding your client wanted. It found a discovery violation, right?
It did make a discovery violation.
The only question we're talking about is whether the remedy was an abuse of discretion, yes?
Yes, Your Honor.
And it just seems to me that when the trial court issues a careful explanation of what it's doing and takes away the most serious charge, leaving only the misdemeanor standing, and it explains why it's drawing that distinction, it's awfully hard for us to say that's an abuse of discretion, isn't it?
I would agree with you under normal circumstances. The issue, Judge Yates, is that the trial court's reasoning there was that she stated that she believed that the unprovided or not provided discovery related to that most serious charge.
Right.
But
more significantly, not that it didn't relate at all to the basic domestic violence misdemeanors, but more seriously, the strangulation charge, right?
It more directly related to that. Although the detective who, and just to be clear, we're not claiming there was any sort of malfeasance or ability,
They just
intent.
it didn't get downloaded.
It didn't get
It's
downloaded,
happened, yeah.
right? And so the detective said that not only were there interviews of, and I'm going to be careful here, BMC, with respect to the incident involving the strangulation, there were also interviews about the other 2 incidents, which comprised the 2 misdemeanor elements. And there were also photos, and there were also interview of the respondent and his father that no one ever saw. And so
those, we also don't know what those are, right?
We don't know
never
what
really
those
made
are.
it into the record.
That's right.
And so, I mean, what do we do with that? Usually what we do with undisclosed evidence is we try to figure out if it would have made a difference in the outcome. And it's hard to know whether that's the case, because we actually don't know how powerful this undisclosed evidence was.
That's right, Your Honor. The thing that I guess I would have thought would have been a more appropriate remedy here, rather than making this ruling and continuing on, is to say, take a week, review all this discovery so you can get your cross-examination in order. But the respondent was denied that opportunity. He had to just roll with it that afternoon.
Well, just to be clear, as far as the photographs go, the victim took pictures of herself for both of the counts of adjudication, right?
She did, Your Honor.
So there's no argument that those were doctored or changed in any way. It was an accurate depiction of what she looked like after each incident, right?
That is, there was nothing in the record that said that she doctored those photos or anything like that.
And then you had the testimony of Sergeant, is it Steinaway?
Steinway, yes.
Steinaway, that the redness on the lower neck, broken blood vessels around the eye, black eye with yellow bruising. So people testified to what they saw as opposed to having that in there, so.
Yes, that's correct, Your Honor.
Okay,
Yes.
so although that would have been nice to give some extra time, we don't know why they didn't go that way. But again, the solution here, the court explained very carefully why it did what it did.
I guess what I take exception to in this case is the fact that the referee here specifically stated that there were inconsistencies in BMC's testimony. And if she gave lengthy interviews about all three of the incidents, that seems very likely that that could have been explored at greater length by respondent's counsel, and he was deprived of that opportunity. So other than that, I would rest on my briefs unless Your Honors have any questions for me.
Thank you very much.
Thank you very much.
Good afternoon. May it please the court, Brandon CCI for the people. I actually agree with Ms. Helton's suggestion that the proper way of moving forward for the trial court would have, or for the referee would have been to take a week recess or adjournment and allow the defense a meaningful opportunity to review that evidence. I think that that would have avoided the problems we're dealing with this appeal today. And that is in fact what the trial prosecutor suggested. Unfortunately, that's not what happened. But let me start by acknowledging an obvious blunder on my part in my brief is that you already know where I'm going with this, is that I did my entire analysis citing the criminal court rule for discovery. It should have obviously been the juvenile delinquency one. And
Fine.
well,
We
thank you.
got it.
Right. That's no problem at all. So if you think you have egg on your face, don't worry about it. That's
I
not a
appreciate
problem.
that. So I don't think it ultimately changes a whole lot. I think it actually maybe makes the answer more clear of what kind of analysis the court should be looking at. One thing that it does change is that I had cited criminal cases that I think strongly stand for the proposal that lack of prejudice would be determinative, and I no longer think I have strong support for that, but I do think it is an important factor to consider anyway, especially since MCR 2.313 sub C1, which would be the applicable core rule for sanctions. There's a default sanction of suppression of evidence or preclusion of a witness's testimony, but the core rule also specifically mentions that if the discovery violation is harmless, that could be grounds for the trial court to just to not hand down that default sanction. So I think that is an important one to consider.
Suppression of the evidence doesn't do us any good here.
No, it doesn't.
They want the opposite of that.
I know. Yeah. Well, that's where there's a little bit of a breakdown, I think, in treating these cases that are sort of criminal adjacent as civil ones, because the interests are pretty different from what you might have in a typical civil case. But regardless, once I realized my mistake, I did a search for cases, obviously, with the juvenile discovery rules. The only one I could find was the unpublished Hale case, which was discussed at pretty much in length in Ms. Helton's brief. That case, I think the circumstances are very different from this one. There were two major discovery violations, and they were ongoing, one by the lead detective in that case and one by the prosecutor. In each of those people multiple times was specifically told by ordered by the court or requested by the defense, hey, we need this discovery, and they did not provide it. The court in Hale did mention, it didn't go through these individually, but it did state that the framework it was looking at was the 8 factors listed in Dean versus Tucker, 182 Mishap 27, which again goes through the civil rules. I think that makes sense. And and I'll just go through those kind of briefly. But I think the difference between this case and Hale will be
But at the end of
obvious.
the day, you don't need to go through all of them
Okay,
individually. I
if
mean,
that's,
we're,
okay.
we're on appeal. We're not a trial court making initial findings. At this point, all you have to do is convince us it was not an abuse of discretion to impose a discovery sanction that was rather severe, taking away the biggest charge, but leaving the misdemeanors in place. How about you do that?
I appreciate that. So I won't go through all of them. I'll just state that of the 8, there's one that I think would weigh in favor of dismissing the case, which would be the 4th one, actual notice to the other party of the evidence and length of time prior to the trial that the other party received such actual notice. Obviously, there wasn't any such in this case. I think the other ones all pretty strongly weigh against dismissing. The last point I wanted to state, the Hale court also cited another civil case, Bass versus Combs, 238 Mishap 16. I'll just quote a couple sentences from that, and I think that'll sufficiently make my wrapping up point. The trial court should carefully consider the circumstances of the case to determine whether a drastic sanction such as dismissing a claim is appropriate. Severe sanctions are generally appropriate only when a party flagrantly and wantonly refuses to facilitate discovery, not when the failure to comply with the discovery request is accidental or involuntary. And in this case, I think it is clear that it was accidental, it wasn't voluntary. There was no trying to spurn the court's orders or rules of discovery in this case.
Well, I mean, yes, I think, I mean, had this evidence been, had it been clear that this evidence had been exculpatory, I mean, we're dealing with, I know we call these civil cases, but they also implicate liberty interests. So I think we might be in a different place than our standard weighing, balancing of discovery factors. But we've been here, we've been looking at things, and it just doesn't, there's no real indication that it was exculpatory. So
yes, I agree with that. And to this date, the only thing that I think is missing now are that interview of the respondent and his father, and typically the only evidentiary value that would have would be used against him, not in his favor.
Right, he can't put it in, it's hearsay. If he tries to get it.
Anything further?
Thank you very
Thank
much.
you all.
Anything? No. Okay, thank you very much both for being here. That case will be submitted. The next case on our docket is item number 8, docket number 369013, Estate of Brooker versus Trinity Health, Michigan. Welcome and thank you for your patience.
Good afternoon. Beth Whitman appearing on behalf of the plaintiff. In this case, summary disposition was granted based upon the fact that the plaintiff filed the complaint on day 182. So there is obviously the Burton decision, there's Hax Ludo, there is the Tyra decision, but I am here to argue that, of course, my client still should win in that summary disposition should be in fact reversed. The first issue obviously that I want to say is that there was no compliance with the court rule, MCR 2.112L2A, which specifically states that if there is going to be a challenge to the notice of intent, it has to be done at the time that there would be a response to the complaint. And that wasn't done here. They instead filed an affidavit of non-involvement. And then later, I think 4 months later, they filed the motion to dismiss. So there was no compliance with the court rule. And not only was there no compliance with the court rule, there was no attempt to argue good cause. There was no finding of good cause by the trial court either. So based upon that, this was an untimely challenge under this court's decision in Sanders. The timing of the notice of intent, the waiting period, these are things that have to be challenged pursuant to that court rule. And it's also incredibly important in this case too, because had they done a timely challenge, statute of limitations had not expired at that point.
Right.
So
it could have fixed the problem.
Exactly. That is a crucial point here. If it was raised appropriately, it could have been fixed.
So this court rule says that the challenge has to be made by motion at the time the defendant files its first response to the complaint. And then it says, comma, whether by answer or motion.
Correct.
So is an affidavit of non-involvement one of those things, an answer or motion?
I think so, because if you look at MCL 600.2912C, which deals with the affidavit of I hope I have that
I
right.
think you're right.
Okay, good. That deals with the affidavit of non-involvement. It says specifically that it can be filed in place of the answer to the complaint.
Right, so doesn't that suggest, if it's filed in lieu of an answer, doesn't that suggest that it's not an answer?
But it would still be the same thing. I mean, you're still filing something in, as opposed to an answer, even if it is an affidavit of non-involvement, it's still your first response of pleading. So I think it still falls within this court rule. So the second issue that we've raised as well is with respect to MCL 600.2912B9. That provision allows you obviously to file the complaint at any time if the defendant has indicated that they're not going to settle the case. There was a response to the notice of intent. They said this doctor, Dr. Chung, had absolutely nothing to do with this patient, had nothing to do with the patient, wasn't involved in the infusion of the drug that was considered involved in the toxicity of the patient, wasn't involved in the programming of the pump, had nothing to do with this patient whatsoever. And under those circumstances, it certainly was appropriate for the plaintiff's attorney to take that as a written statement that there was not going to be a settlement of this case during the notice period. And it's important too, there were 46 days left in that notice period at that time. That was it.
Would that be your position for any affidavit of non-involvement or this particular affidavit of?
This is different. This was their response to the notice of intent.
Oh, that's right. I'm sorry.
Yes. So it's a different.
Was it different than what the?
I think it's about the same. I mean, it's considering the first thing that they did was file a notice of non-involvement, or I'm sorry, affidavit of
So you're
non-involvement.
saying that the response to the NOI, if it essentially is the equivalent of what would be an affidavit of non-involvement later, that should trigger the thing that allows you.
The thing that allows you to, exactly, under 2912 B9. That's correct.
The unwillingness to settle the claim is different than saying we think we have a lay down winner as a defense, isn't it? I mean, can you treat the two as one and the same?
I think under these circumstances, I think it's a fair assessment by the plaintiff's attorney that this means they are not going to settle this
Any
case.
cases that support that position?
There is very few cases on this
Okay,
subsection.
Thank you very much. Thank you. Thank you. I was hoping we had missed something. So,
Very few cases on the court rule too. Sanders obviously is published. It's a decision of this court, and it supports our position, but not a lot of cases on those.
I mean, a lot of people say, and this might be partly posturing, partly not, but my client had nothing to do with this, but he or she or they really do not want to go through this litigation, and so we're going to offer you, a paltry sum, and then maybe we could call it a day.
And that could be the case, but there was certainly no indication that there was a paltry sum that was going to be coming. I mean, there was certainly
Nuisance value or something.
exactly. There was no indication. This was a flat out. This doctor had nothing to do with this.
but that's the lay down defense that Judge Yates is talking about.
That there was nothing.
I'm not involved.
I was not involved. Yes.
Unwillingness to settle versus, here's my defense. My name's not on anything.
And what I was getting at is that there was nothing in the response to the notice of intent that would indicate to the plaintiff's attorney at that time that there would even be a settlement for a paltry amount either, a nuisance value either. So under these circumstances, I think it was appropriate for the plaintiff's attorney in this case to take this response to the notice of intent and say there was not going to be a settlement.
Just the fact that the plaintiff's attorney waited until day 182 factor into what they might have been thinking?
Maybe it doesn't, but still the problem is that filing on 182, it's improper. It couldn't happen under Hack Saludo. And whether or not it happens on day 181 or 182, I don't know if that matters much one way or the other, what the plaintiff's counsel was thinking. It's just, it was appropriate under those circumstances to believe that there was not going to be a settlement, because
Wasn't-
that's the
But
point
wasn't
of a
there more
notice.
time because he was only one of 1, 2, 3, 4 defendants.
That's correct.
So you're saying that when you get an affidavit or statement like we had in this case from one defendant, that you can just act against all of them before everybody's had a chance to go ahead and
To go ahead and fight, yes.
Why? That
Because
doesn't look like the legislative intent of the language of the statute.
And I believe, is it the hospital that's responsible, vicariously liable for the doctor as well? So that's,
Yeah, but then we also have Global Anesthesia Solutions PL.
yes, who's also her PC. So these are all part and parcel of the same defendant. So that would be appropriate. If you're not going to settle, if your client has done nothing wrong, I think it's appropriate to, under those circumstances, rely upon the response that's filed by the single defendant doctor, that defendant doctor had nothing to do with this
Do you have
case.
case law that says that?
I do not know.
Thanks very
I
much.
Can I ask you a question about
Of course.
Ms. Whitman, it seems odd that there's no law on any of this. Now, I will readily admit that you operate at a much higher level of sophistication than almost anybody we ever see in front of us.
Thank you.
And I mean that as the ultimate compliment. Are these arguments not being made?
Well, I think a lot of these notice of intent issues, a lot of these affidavit of merit issues are no longer a big problem now that we have had the court rule in effect. You have to make these challenges. So these statute of limitations problems are not as common as they used to be. It used to be a death knell for a defective affidavit. It used to be a death knell for a defective notice of intent. They're not anymore.
Is it necessary or just helpful if we publish in this case?
I think I absolutely would take a published decision in this case, particularly.
It seems to me that these are important issues that ought to be settled.
Yes.
I can't believe that there's nothing out there.
And the problem is too, and this gets to I'm jumping over an argument, but it's fine. Burton absolutely was wrongly decided. It absolutely was wrongly decided.
We're stuck with it.
We're stuck with it. I completely understand that this court is stuck with that decision, but I would take a published decision from this court saying that they're bound by Burton, and I would absolutely appreciate if the court were willing to agree with my position, at least to some extent, that Otkin really does put Burton, it questions the viability of Burton. It really does. Burton, Tyra, and Hex Ludo, obviously, it was more of a timing issue. It was more the calculation issue, but it has the statements in there that relies upon Burton, that if you file on day 182, you haven't timely commenced your action, and you don't get tolling of the limitations period.
It just seems to me that this is such a trap for the unwary.
It absolutely is.
If there's a trap door to be provided, we ought to think seriously about that.
And that's why I think that court rule is so important. That court rule is vitally important in this case. If I win on the court rule, though, I don't necessarily have to take up the Burton issue.
Of course,
it'd go back.
You found a way around
I
it.
found a way around it, absolutely. Unless it was
If you
for some.
lose on the court rule, you could go to the Supreme Court on Burton.
Pardon?
If you lose on the
If I lose on the
you
court
could
rule,
go to the
absolutely.
Supreme Court on Burton.
If we go back to the trial court, if there's a remand to the trial court and the trial court says, you know what, I'm going to make finding that there's good cause here, then I'm back stuck with Burton. That's the other problem too. But again, there was no finding of good cause by the trial court under the court rule for doing an untimely motion. But Burton absolutely, I have teed up as much as I can the challenge to Burton. It just cannot stand after the Otkin case reverse Scarcella. That's all there is to it. So at least that's our position. Obviously, I understand, of course, that this court is bound by Burton, by Tyra. The only other argument that I presented too is based upon 600.2301, which again, Tyra said if it was a similar type of premature filing of the complaint before the expiration of the notice period, it wasn't a day 182 case, but and that's where I am marking the distinction.
I think the sister case to Tyra was a day.
Was it a day 182?
Ferris.
Yes.
Yeah. I
But
think it was a day 1 and
so
182.
here, the whole point of the notice of intent is to allow the time for settlement, essentially.
Right.
Here, you file on 182, they don't even know that the defendants don't even know that there's a premature filing at that point. They're not served with the complaint on day 182. They have been afforded the full 182 days of notice. That's all there is to it.
You're making all the sense in the world. It's just
Okay,
we're stuck with
good.
some things.
Okay, as long as I'm making sense, that's wonderful. I'll take that. I'd be happy to answer any further questions. If not, I will take the rest of my time for rebuttal. Okay, thank
Thank
you.
you very much.
Afternoon.
Hi.
Nice to see everyone.
But this is an all-star battle today, I'll tell you.
Yeah, they said downstairs we're supposed to be fighting more than this. Jackie Klein on behalf of Dr. Chung and Global Anesthesia. I think I'm going to go a little out of order here. So I'm going to start with the court rule and why it does not apply in this case. Number one, it's unpreserved, so it's not properly before this court.
Well, yes and no. I mean, TOLA still allows us to get to it, right?
I'm sorry?
TOLA still allows us to get to it in extraordinary circumstances when the factual record is
TOLA's.
developed and it's essentially
I
just
think
a
it's
question of law.
manifestly unjust.
Well, that's Judge Phoenix. She wrote TOLA's. She's
trying to-
smiling down there. She knows
We
the
left
answer.
a little door, a little crack in the door. So.
Very little crack, yeah. Well, it's my position, it's not properly before the court and it does not meet that very high standard. Number two, there is no challenge to the notice of intent here. It's not defective, the content's fine, the address was fine, we received it, we responded early, there's no.
Isn't that what Sanders addresses though? Doesn't Sanders say?
Sanders,
Everything NOI related comes in?
that statement was pure dicta. The Sanders court decided that the address, which is part of the NOI, which was the part that was defective, that's all that Sanders actually decided. And unfortunately, that is kind of the only published case under this. Another reason it doesn't apply, we haven't
But
answered
you'd say
yet.
we would be going against dicta, but not against a holding to take your position on that.
Right, if we had a defective address, then I think Sanders applies, but we're not contesting that they sent it to the right place. Obviously, we answered, so we received it.
But there is a statement in Sanders that
Yeah,
says,
dicta.
right, yeah, okay.
Yeah, they list different examples of what could be.
You're saying that statement is dicta because
Right.
it's not the particular example that was at issue.
Right, and that example wasn't, as far as we know, wasn't fully briefed, argued because it wasn't an issue, so it shouldn't be binding. And the third reason is we have not answered the complaint yet. The whole point of this court or of this statute is, when a plaintiff gets the medical record and they name 50 doctors and all their healthcare providers, this allows the non-relevant defendants to get whittled out before they have to spend costs in litigation.
Sure.
So we don't answer the complaint until one of these has been successfully opposed. Usually it's, you send an affidavit of non-involvement and you get a stipulation to dismiss and it doesn't get litigated, which is why there's not a lot of case law on this. Because it's not usually an issue here.
It's an odd process. So much
Yeah.
gets done before the complaint's even filed.
Right.
I mean, I get it. That's the legislature's choice. We can't second guess it, but it does seem to.
And the statute says instead of answering or otherwise pleading. So it's not an answer. It's not a response of pleading. Fourth, under Burton and Tyra, because this was filed early, technically the lawsuit never commenced. So our time for answering never started because we have no lawsuit.
Yep.
So.
Yeah, and whether that's a fiction or not, we're stuck with that. That's the law.
Right. And I won't argue. I mean, obviously we think Burton was correctly decided. You have a 182-day period. You can make the argument, oh, it's only 1 day for anything with any statute of limitations. Oh, it's unfair, but you got to have a cutoff.
You don't have to worry about that. That has to happen
Yeah.
upstairs. It doesn't happen on the second floor.
So, and I think those two cases basically decide this whole this whole appeal right now. As far as the argument that Aachen changed anything, the court specifically declined to decide this issue in that case. As far as the 2912B9, it has very specific language that you have to say, we don't intend to settle or we waive this period. I don't think we get to presume that they would not have settled if plaintiff had offered a nominal amount. Maybe one of these defendants would have been like,
to go your own way. And
better than paying you, Jackie. It happens all the time. So I don't think we can make that presumption here. And
Even on day 182, because maybe they would have gotten an email at 9 p.m. that night.
Mhm.
Hey, here's.
it was about ready to go.
I've seen
guess it's-
crazier
right,
things
I guess it's
happen.
possible.
But there has to be a cutoff, and the legislature decided that that was a cutoff. So there we are. Any questions?
Thank you very much.
Thank you.
Ms. Whitman, any rebuttal?
I disagree that it's dicta and Sanders. I think that is the core holding of the case when this court says, whether a challenge raised by a defendant is based on the timeliness of the notice of intent, the plaintiff's compliance with the notice waiting period, a claim that no NOI was received, the contents of an NOI. They said consequently, each of these different types of challenges is just one of the possible grounds on which a challenge to the substance has to be made under 2.112, and it applies to all challenges to a notice of intent. So I think this court did.
You're saying the all is the holding.
That's
and
exactly it.
And all of the other things are just necessary.
That's necessarily fell within that.
Fell
In
within.
the quotes is actually from the opinion. It's not even just my air quotes. It's from the opinion, all. And that's because that's exactly what the language in the court rule states. So that's all I have to say, unless the court has any questions. Okay,
Thank you very much. Good
Thank
to
you.
see you all. That case will be submitted. I think the remaining cases, which I will call, do not have oral argument endorsed. Those cases are item number 9, docket number 373853, Brown versus Ajax Mortgage Loan Trust 2021-A. That case will be submitted on the briefs. Item number 10 is docket number 375483, In Re Quinton Miners. That matter will be submitted on the briefs. Item number 11 is docket number 376845, In Re Scott Stewart Miners. That matter will be submitted on the briefs. That concludes today's case call, and we will see you tomorrow. Thank you.
Lastly,